Good morning, everyone. Call this meeting to order. Aloha, mai kako. Good morning. Good morning. This is the April 4th, 2024 Land Use Commission meeting. This is an in-person meeting. It's being held at the Homer A. Maxey Center Conference Room, Foreign Trade Zone number 9. The address is 521 Ala Moana Boulevard, Honolulu, and this meeting is open to the public. For all meeting participants, I'd like to stress the importance of speaking slowly, clearly, and directly into the microphone. Before you're speaking, please state your name and identify yourself for the record. That, if you can, that'd be each time you speak. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, and it will be posted on YouTube. And it will be used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. I also want to advise that we will be taking breaks throughout the meeting, nominally 5 minutes or so every hour or so. And if the meeting continues through the lunch hour, we will take a lunch break as well. My name is Dan Giovanni. I have the pleasure to serve as the LUC chair. We currently have 9 seated commissioners. Along with me today are Commissioner Lee Ohigashi from Maui, Commissioner Gary Okuda, Commissioner Koike Kamakea Ohelo, Commissioner George Atta, Commissioner Brian Lee, and Commissioner Mel Kahele, all from Oʻahu. We have Commissioner Nancy Carr Smith from Island of Hawaii, and we have Commissioner Michael Yamane from Kauai. Also in attendance are LUC Executive Officer Daniel Orendanker, LUC Chief Planner Scott Derrickson, LUC Staff Planner Martina Segura, LUC Chief Clerk Ariana Kwan, LUC Development Coordinator Arnold Wong, and LUC Attorney General Dan Morris. Our 9th order of business for this 2-day meeting is A92-683 Halekua Development, a Aseko Royal Kunia motion for order amending the Memorandum of Understanding. This time I'd like the parties to introduce themselves, starting with Mr. Curtis, to Mr. Tabata please introduce yourself and whoever you have with you.
Thank you, Chair. Morning, Curtis Tabata and Benjamin Matsubara for Aseko. Also present with us to my left is Aseko Vice President Peter Kwan and Aseko in-house counsel Kelly Uwaini.
Thank you very much.
Good morning, Chair and Commissioners. This is Jennifer Lim representing Ho'ohana Solar One LLC. Mr. Green, who was with me yesterday for the status report, has had to get a flight, so he's not with me today. I'm on my own.
You're flying solo today.
Correct.
Okay.
Thank you.
Ms. Lee.
Morning, Chair, Commissioners. Terry Lee, counsel for RK2 Partners. To my left is my co-counsel, Derek Kobayashi. Also in attendance, our co-counsel, Eric Elkind, Ernie Martin. Thank you.
Thank you very much. I see the chairs are absent for Robinson Canuya Land. If they show up, we'll introduce them when they do. Parties from the county, please introduce yourself.
Aloha, Chair and Commissioners. Pono Arias, Deputy Corporation Counsel on behalf of the city. With me, I have Dino Wong from the Department of Planning and Permitting and Brad Saito, Deputy Corporation Counsel.
Great, thank you. From the Office of Planning and Sustainable Development.
Good morning, Allison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here are Katia Balaciano and Aaron Sotagawa from OPSD. Thank you.
Thank you very much. And from the Department of Agriculture.
Good morning, Kelsey Nagata, Deputy Attorney General. With me, for the Department of Agriculture. With me is Brian Kao and Janice Fujimoto.
Thank you very much. At this time, I'd like to briefly explain our procedures for today's hearing. First, I will ask the commissioners if there are any disclosures that they'd like to make. And then I will update the record accordingly. Then I will recognize the written public testimony that has been submitted in this matter, identifying the person or organizations who have submitted the testimony. Next, I will call upon members of the public who wish to testify on the motion. Members of the public will have 2 minutes to provide their testimony and should stand by after their testimony to respond to any questions by the parties or by the commissioners. When questions have been completed, the chair will excuse the witness and call the next witness into the witness box. After completion of the public portion of the testimony in these proceedings, the chair would like petitioner Halekua to provide their presentation on the motion. Following their presentation, other petitioners will present. The chair will then call upon the county's planning department, the Office of Planning and Sustainable Development for their presentation on the motion. The petitioner will then be allowed to respond to comments made by the county, the Department of Agriculture, and OPSD. Similar to yesterday's hearing, I will call on the Department of Agriculture prior to calling on the state and calling on the county. Commissioners will ask questions of the parties at the conclusions of each of their presentations. At the conclusion of the party's testimony and the commissioners' questions, the public will again be granted the opportunity to provide additional and or new public testimony in the same manner as before. Once the public testimony concludes, the commission will enter into deliberations regarding the motion and decide how to proceed. Again, I note we'll be calling for short breaks on an hourly basis and a longer one through lunch as necessary. Are there any comments or objections to the procedures as I've laid them out? Mr. Tabata.
No comments or objections. Thank you.
Thank you. Ms. Lim.
No, Chair.
Mr. Lee.
Nothing here.
Thank you. County.
No, Chair.
Thank you. State.
No, thank you.
Department of Agriculture.
No, thank you.
Great. Thank you. Commissioners, do you have any disclosures that you would like to make regarding this matter? Seeing none, we'll proceed. I'd like to make a reference for the record. Please be informed that all relevant records and documents pertaining to this matter can be accessed for review on the LUC website. And you could find that at https://luc.hawaii.gov/A92-683. Now I'd like to go over the reimbursement policy for today's hearing. Good morning, Mr. Tabata. Again, have you reviewed HAR section 15-15-45.1 regarding the reimbursement of hearing expenses?
Yes, Chair, and we will comply.
Thank you very much. I'd now like to recognize public written testimony. Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair.
Thank you very much. Next, I would call on any members of the public wishing to provide testimony on this agenda item. Ms. Kwan, are there any members of the public present who would like to testify?
No, Mr. Chair.
Very good. As I said earlier, if Mr. Lau shows up, we'll give him a moment to introduce himself and who he represents.
Yes, Stephen Mao on behalf of Robinson Cuneo Land LLC, and I must apologize, I was waiting outside. I thought it was starting at 9:30.
No problem. Thank you for joining us today. We appreciate it. Yeah, let me just it's very encouraging when we have a matter that involves 4 different property owners and all 4 show up. That's just terrific. And I mean that, that's really appreciated. So thank you all. What'd you say? Oh, yeah, except for the school. That's number 5. 4 out of 5 ain't bad. Yeah, yeah. Okay, where were we? So now I'd like to turn to Haseko and for them to make their presentation on the motion.
Thank you, Chair. Curtis Tabata. We spent a lot of time yesterday talking about this, about the MOU and everything, but I know Commissioner Kamakelo was not here, so let me just briefly go over, why are we here today? So back in 2021, the LEC issued its order, and in that order, there was a condition called Condition A1. Okay, and this condition required the landowners to enter into an MOU, a memorandum of understanding with the Department of Agriculture, within 6 months of the order back in 2021. And the memorandum of understanding, the MOU, needed to contain a description of the offsite infrastructure required for the agricultural park. And that offsite infrastructure in the MOU needed to have a deadline. And that deadline was June 30th, 2023. Okay, so the landowners would need to complete the offsite infrastructure for the agricultural park by that date in June 2023. That date came and went. Offsite infrastructure was not built. We attempted to negotiate an extension, but there wasn't enough time. So after the deadline lapsed, we continued to work with the Department of Agriculture, and we executed a Fifth Amendment to the MOU with 3 new deadlines. So the offsite infrastructure comprises of, in Condition A1, all utilities, electrical, potable water, roadways, sewer lines, and communications. As we were negotiating with the Department of Agriculture, we learned that they had a priority. Okay, they needed functional electrical power and potable water for agricultural use. They needed that as soon as possible. And 2025 was the end of 2025 was their minimum requirement. That's what they told us. So we had to carve out those 2 infrastructure requirements, electrical power and potable water for agriculture, and we called it temporary. Okay, and we have to complete that. We have to complete that by the end of 2025, December 31st. Everything else is going to be provided by September 30th, 2028. We call that the permanent infrastructure. Okay, that's going to have everything. That's going to run along road Y. So it's going to be, the normal infrastructure runs underneath a roadway, and it's going to have everything. And that's based on our construction schedule, our master plan schedule. That falls into 2028, and that was acceptable to the Department of Agriculture. A third category is the irrigation infrastructure. So this is the non-potable water that's going to be used for irrigation, and that consists of a 12-inch water line that Ho'ohana installed. Haseko is going to install the pump station, which is going to pump out the water from the adjacent reservoir number 225. And we are required to complete the pump station installation by the end of August of this year, 2024. So we have to break down the offsite infrastructure into those 3 categories, those 3 different deadlines, and it was agreeable to the DOA. So we signed off on that MOU in January 10th, 2024, this year. And then thankfully, we were then able to prepare this motion to change the date in condition A1, because condition A1 has that June 30th, 2023 deadline, and but we had to come basically extend the deadline, you know, so that it will be agreeable to the Department of Agriculture. And what we're doing now is trying to amend this condition A1, change it so that the deadline date for the completion of the infrastructure matches the MOU we signed just recently in January. So that's why we're here today. So the basis for our motion, the reason why we would like our motion to be granted is because we have signed the MOU. The Department of Agriculture is in agreement with these deadlines. We would like condition A1 to be consistent with those deadlines. So that's the basis for our motion. There are legal issues related to our motion. There is Commissioner Okuda mentioned it yesterday that, just to put me on notice. Kapaakai, chapter 343. And I mean, I write about it in the motion, our position and why we're not legally required to do a Kapaakai analysis for this motion, and a supplemental EIS is also not legally required for this motion. I mean, and the short of it, the basic reason why we're taking these legal positions is because the motion seeks to change the date in condition A1 for the offsite infrastructure completion. That's it. Okay, we're not asking for permission to build the project. We already have the obligation, really, and right to construct a project, build the infrastructure that's required for our project and for other projects, like for RK2 partners, Department of Agriculture. So we already have that right. That's our position. And the motion that we're here for today specifically is just to change the date in condition A1. And because of that, we're not affecting anyone's rights, is what we're saying. Because we're just changing a date. We're not proposing any construction today, any development. So I know Commissioner Okuda has questions for me, so I'll let him ask his questions and address those legal issues in that way. I think that's more efficient. Thank you.
Thank you, Mr. Tabata. That concludes your presentation.
Yes, thank you.
Thank you. Commissioners, questions for Mr. Tabata? Oh, Mr. Okuda, please proceed.
Thank you very much, Mr. Chair. Mr. Tabata, to sum up maybe the bottom line of your presentation, are you basically saying that what you're asking for, the relief that you're asking for, is not material, and so it's really no big deal?
I wouldn't say it's not a big deal. If you deny the motion today, our position is we still need to build a project and we still have the right to build a project. Okay, so a natural question is, well, why'd you file a motion then? Right? And to be honest, it's because out of respect. If we did not file the motion, if we ignored condition A1 and the deadline, and you guys brought us in for a status hearing, we would face a very angry commission. Okay, I mean, that's just based on experience. So this is important. We're not taking this lightly. I'm not sure if that answers your question.
Yeah, well, maybe I can be more specific. If for some reason the commission denies your motion at this point in time. Okay, I'm not saying it's a denial with prejudice, meaning you can't bring it again in the future. But if it's denied at this point in time, does that affect your ability to develop in any way?
The only impact I could see it having is that we would be inconsistent with that deadline. And I'm not sure if the commission will take further action against us.
Well, you agree that the commission is bound by the decision made yesterday that after hearing all the evidence that was presented, and me personally, you know, I would have made a factual finding that, and I think I did say that your witnesses are very credible. Based on the decision yesterday, the commission is really bound not to do anything inconsistent with yesterday's decision, which is basically take no further action on the fact that certain deadlines might not have been strictly complied with. Well, let me break that up. Do you agree that yesterday's decision indicates that the commission has decided that after hearing the evidence, no further action should be taken, even though there might be slippage or non-compliance with certain deadlines?
Yes, I would like to believe that, yes. I
Yeah.
would-
And the commission is not supposed to be inconsistent, especially in a in a specific docket. The commission is not supposed to be inconsistent with prior decisions in that docket, correct?
Yes,
So in other words, would it be a fair statement to say that even if the commission were to deny your motion at this point in time, based on yesterday's decision, the commission really cannot turn around and say in the future, well, we're now going to actually bring you forward on an order to show cause because you didn't comply with the deadlines which were actually discussed at yesterday's hearing.
yes, I would agree with that.
Okay, so in other words, if the commission were to make a decision that maybe certain things are deficient, and there should be time given to correct it, wouldn't you agree that that really would not create any type of legal barrier to your client or you moving forward with this memorandum of understanding with the Department of Agriculture?
Okay, I think that would be the case with Kapalkai. You know, if you folks tell us we need to do a Kapalkai analysis, I think we can do that and continue with the project. The supplemental EIS issue is a little bit different. Okay, chapter 343, the way it's written is if you have to do a statement, you cannot proceed with your action until your final statement's accepted. Okay, that's in the statute. All right, I mean,
Okay,
So-
well, yeah, I don't mean to interrupt you, but we
Right.
can cover the 343 issue because but really quickly regarding that, you agree right now, no one, and I mean no one, has made or made a statement on the record or anywhere else in public testimony or otherwise that a lack of a 343 analysis or an update prevents you or your client from moving forward in any portion of your project, correct?
correct.
Okay. You have many, many years of experience in the land use area. Do you agree with that?
I have experience, yes.
Yeah, I know, and you're a modest guy, and I'm not trying to stroke your ego or anything like that, but you're a modest guy. But let's face it, you and Mr. Matsubara are considered experts in this area. And you're going to be modest, so you're probably going to downplay that. But let me ask you this, just to put my next question in context. Okay, without getting into the argument regarding whether the super ferry was a good idea or not. Do you agree that one of the things that torpedoed the super ferry was people's just, you might call it hard-headed insistence that they just wouldn't do, for example, Chapter 343 environmental impact statement. And if they had just done the impact statement while all this litigation regarding super ferry was pending, we still might have a super ferry. That sometimes, to get a project done, it's better to check off some of the boxes. We might disagree as a matter of public policy whether those boxes are there. But if the legislature has set forth the boxes, then they should be checked off. Otherwise, a good project might be sunk in the end. Is that a fair statement? I'm not saying it applies to this case, but just generally speaking, based on your experience in this land use area.
In general, I would agree that, I don't like shortcuts. I don't like it. I don't, if a developer says, I want to try to take a legal shortcut and avoid an obligation, I just as you described, if there's a challenge, you can get overturned, and it's going to set you back time-wise. Okay, so I'm not here to criticize the Super Ferry project or how they handle their handling of Chapter 343, but there are legal requirements. There are legal standards that then make it applicable to require an environmental assessment. Okay, I mean, there are tests that need to be fulfilled in order for you to be legally required to do an EA or EIS. Okay, so and if you're not legally required to do so, you should not then be required to perform those statements. Okay, so I mean, and we can discuss why we think we're not legally required to do a supplemental EIS. And I think that's how it should be handled. We follow the law, basically.
Oh, okay. Let me back up and first start with Kapa'akai then, and maybe we'll go over the legal standard there, and you can help me out with, this area which seems to be open for interpretation. And I won't go over the history of Kapa'akai because in this room and at other hearings, we've gone through the constitutional provisions. We've gone through the historic reasons why Article 12 was passed by the 1978 Constitutional Convention. We all might have been working on staff at that time, so I won't go over that. What I'd like you to comment on is what constitutes an act or action which triggers a Kapa'akai analysis. And what I'm reading from is the Kapa'akai case, and that case, of course, is titled Kapa'akai versus Land Use Commission, State of Hawaii. That's 94 Hawaii 31. And this portion of the case is found at pages 45 to 46. What the Supreme Court said is, as such, state agencies such as the LUC may not act without independently considering the effect of their actions on Hawaiian traditions and practices, close quote. Okay, as that term act or terms act or actions are used in that sentence, what do those words mean?
The word action refers to a project. Okay, I mean, so when it says what does the act, how does that, it's a three-part test, right? First you identify the cultural practices that are taking place, that are identified. And then the second test is what impacts the action would have on those practices. And then the third test, I believe, is there any mitigation that can be applied to protect those rights? So the action is a description of the project. Will the project affect those traditional and customary rights?
Yeah, but before we get into the three-part test or analysis of Kapaakai, the first question is the case or the standards in the case triggered, correct?
Okay, the triggering for a Kapaakai analysis, in the Flores case, Ohana, they clarified that in Kapaakai, it was the analysis was required for a district boundary amendment proceeding, which is a contested case proceeding. So what triggers the analysis in Kapaakai was the contested case. Okay, and in Flores case Ohana, the trigger was then expanded to rulemaking. Okay, and so CJ wrote Flores case Ohana, and he laid it out basically that, like you said, the agency is required to protect traditional and customary rights. In Kapaakai, it was for contested case hearings, which addresses past events, adjudicate past events that has occurred, and in rulemaking, you cover future events. You create law by rulemaking, and so you cover the past and the future with Article 12, Section 7.
Yeah, well, wasn't the specific issue in the Flores case, and just so that we're clear on the record what we're talking about, that's a case titled Flores-Case Ohana versus University of Hawaii that's found at 153 Hawaii Reports 76. The Pacific Third citation is 526 Pacific Third 601. That case, the issue there was whether or not Kapaakai applies to situations or cases in addition to contested case proceedings. Because wasn't the argument by the University of Hawaii in that case, this dealt with what, Mauna Kea, right? Wasn't the argument by the University of Hawaii that, oh, Kapaakai is only limited to contested case types of hearings, not to rulemaking, and the university had arguments why didn't it apply, and what the Supreme Court said is no, Kapaakai is not simply limited to contested case hearings. It's also applies to other things like rulemaking. Is that a fair statement, or what happened in that case?
There is a general statement where they say that the Constitution does not limit Kapaakai to just contested case hearings. You're right. But then in that same paragraph, it goes on to say that, so therefore we are extending the requirements of Kapaakai to rulemaking. So the statement about it going beyond contested cases was used as justification for going into rulemaking, for making it to make it apply to rulemaking. So it's what the court did in Flores case Ohana was to extend the Kapaakai requirements not only to contested case hearings, but to rulemaking.
Okay,
And
well,
and it really doesn't address anything else. And there is a discussion that I would, get into if you want to cover, everything else. That's what I call it. If it's not a contested case hearing, and if it's not rulemaking, then it's basically everything else.
okay,
That-
well, yeah,
you guys do.
this is where we can help me with this, okay? I really think the controlling rule is what's set out in that sentence that I went over with you regarding Kapaakai, basically, which says, as such, state agencies such as the LUC may not act without independently considering the effect of their actions on Hawaiian traditions and practices, okay? And I think that is the controlling rule. Now, this is my question to you. Okay, where do we draw the line? Because setting an agenda and agendizing your motion, that's an action, right? So do we have to do a Kapaakai analysis to set the agenda? Clearly, if you were coming in and asking for a boundary amendment, from agriculture to urban, I don't think anyone would argue that that wouldn't require a kapakai analysis. And I'm not sure anyone would really argue that we have to do a kapakai analysis to send an agenda item, to agendize your boundary application. So where is the line drawn? And what is your legal authority that tells us where to draw the line?
Well, the legal authority is basically Flores case Ohana. It is a case we're talking about, and you know, the land use commission's duty to assess, protect traditional and customary rights. But before it acts, is to me a general statement saying that if you need to comply with Kapolkai, then comply with it. Then you need to then do it. If you need to comply with it, it's that kind of a statement. Okay, but when they talk about triggers, that's why the circuit court certified a question to the Hawaii Supreme Court. It wasn't sure if you could extend, if they were required to extend Kapolkai to rulemaking. They didn't know. Okay, so they certified that question, sent it to the Hawaii Supreme Court, and they said, yes, you have to do it for rulemaking. So, extending it beyond contested case hearings, even the circuit court wasn't willing to expand it beyond contested case hearings. It left it to the Hawaii Supreme Court. So, I think that's what we're limited to until the Hawaii Supreme Court expands the triggers for Kapolkai. I think that's what we're left with. I'm not sure if I don't think it'll be appropriate for the LUC to make new law and to extend it beyond contested case hearings and rulemaking. I mean, so that's our position on that. Where do you draw the line? That's an excellent question. Because if you do go beyond contested case hearings and if you go beyond rulemaking, then where do you draw the line? You're right. If you're gonna do it for everything, then you need to do a Kapolkai analysis whenever you adopt your minutes, take a vote on personnel matters, everything, right? It's not just, it's everything. So and that doesn't make sense when you think about it, because then it gets unwieldy. But what the CG also said in Flores case Ohana was that, if it's clear that traditional and customary rights are not going to be implicated, then you can just say so in writing, and that ends the analysis. He says it's a real common sense type of solution. So if the commission today says, we need to do a Kapolkai analysis, then you could approach it in that way. You could look, okay, Paseco wants to change the date for the infrastructure deadline in condition A1. Could that affect just that? Changing the date, could that affect anyone's constitutional rights? I think a common sense conclusion would be no. Just changing a date is not going to do that. And you could say so in a short statement. It's in the case. I mean, I could.
Yeah, no, I know what you're
Yeah,
saying, and
yeah.
you don't have to cite to that. Okay. One of the things that you submitted, or one of the arguments you submitted in your motion, and your motion and supplemental or your, not supplemental, but your memorandum, clearly discuss all of this. So you really didn't need my notice yesterday to do this, because you already did it. But you also referenced the existing cultural impact analysis, which was done for the solar project, correct?
That's correct.
Now, what exhibit was that CIA? I should have wrote it down. Was it 9 or 10? I can't remember. Well, it was one of the exhibits you submitted with your motion, correct?
Exhibit 10.
Yeah, exhibit 10. When you look at the CIA, for example, page 1 in the introductory section, the cultural impact analysis focuses on a specific project area, correct?
Parcel 52, the Robinson line.
Right. It doesn't specifically state that it applies to Haseko's parcel, correct?
Right. I mean, we cited so that we could make use or talk about how the CIA analyzed the entire Ahupua'a, which includes our land. So yes, it doesn't specifically focus on our property. It focuses on 52 when it makes some of its conclusions. So would it technically satisfy the requirements for a CIA for our land? Probably not, like you're saying. It doesn't specifically apply, but
Well,
They
okay,
could-
let me stop you right there. You don't have to concede that it doesn't apply, okay? Because, and that's why my question goes to that. Okay, because you would agree that the commission can look at all evidence and draw reasonable or make reasonable factual determinations from the credible evidence in the record, correct?
right, and that's why we refer to that CIA
Okay.
that talks about our Ahupua'a.
Okay, and I'm sorry to cut you off, but, and you might continue on by answering my next question. What evidence in the record indicates that even though the introductory portion of the CIA states that it was done specifically for the Robinson parcel, what evidence in the record indicates that you could apply the analysis in Exhibit 10 to the Haseko parcel? What evidence in the record shows that?
Well, there's there's discussion in the CIA that refers to the CIA process, which is not limited just to parcel 52. Okay, it mentions that when you do a CIA, you have to cover the whole area. Okay, you have to go beyond just a specific property, and you have to. So what they did was they looked at the entire Ahupua'a, and their conclusion was that all the culturally significant sites were all located by Pearl Harbor, Makai, in the Makai direction. So that area covers our property. So I mean, as you said, the commission can look at all the evidence and draw reasonable conclusions. And we both grew up in that area, so we know that area's all been plowed over many times over the, I don't know, past 100 years for sugarcane. So, the land over there it's basically all the same. But that's not evidence, I guess.
Well, okay, and the CIA at page 77 contains recommendations, but it appears that the recommendations were limited specifically to the designated project area. What evidence in the record indicates that the commission can make a finding that the recommendation section in the cultural impact analysis, specifically page 77, can be applied to the Haseko parcel?
Excuse me, I should back up a little bit.
Sure.
So when we talk about the CIA that Ho'ohana did, that's what we call an argument in the alternative. Our primary argument is that we're not legally required to do the analysis for this motion. Okay, that's our primary argument. But so when we talk about the CIA, what we're saying is even if we were required to do so, even if this commission has the evidence to look at to see that there in this Ahupua'a, there are no culturally significant sites, at least in this area, except closer to Pearl Harbor, Makai of the property. So is it a perfect match to our property? No, it's not. I'll concede to that. But it's something for the commission to look at and consider. I think it's relevant. And that's why it's offered. But the primary argument is that we're not legally required to do the analysis. But in the alternative, at least we have this CIA that gives us some assurance, some comfort that people were contacted, and they were, they did their analysis and they studied the Ahupua'a, the whole region, and they came to their conclusions. So that's why it's offered for your consideration.
And I'm not trying to put words in your mouth, but just to help me understand the basis of your argument. So if you were to apply the section that kind of concerns me, which is this statement again, and I quote, as such, state agencies such as the LUC may not act without independently considering the effect of their actions on Hawaiian traditions and practices. Your contention is just changing the date of the memorandum of understanding is not an act or an action which falls within that statement in the Kapa'akai case. Is that a fair statement or not a fair statement?
It's not that statement is not a trigger. That doesn't describe a trigger for having to do a Kapa'akai analysis. I'm not sure if I'm exactly understanding your question, but even, how do I put it? The trigger is a contested case hearing or rulemaking. Okay, that's what Flores case Ohana holds. Now, what the question is our motion, the changing the date, is that an act? I think, you don't get to that statement you read about the obligation to protect those rights without considering the action. You don't get to that unless there's a trigger. So we don't get there. But even if you do get there, there is a trigger. Say there is a trigger. Okay. Say this is a contested case hearing. Okay. And so you now we're going to apply Kapa'akai. Now the question is, is our changing the date an action? And let's assume it is something that we're going to evaluate. Like the CJ wrote, what then is the implication? Are those rights being implicated by what is being proposed, which is changing the date? And I think the answer is obviously no. And you could then do that short statement, like the CJ said, and that will end you don't have to do the full 3-part test. You just say, you're changing the date, and that's clearly not implicating anyone's constitutional rights, and therefore the analysis ends there, pursuant to Flores case Ohana.
Okay, let me move on to the chapter 343 issue or non-issue. In the history of this docket, going back to the original application for boundary amendment or petition for boundary amendment, was an environmental assessment or any evaluation under HRS chapter 343 performed at any time in connection with the boundary amendment?
I believe, yes, there was a 1989 EIS and a 1996 EA for this project.
Okay. When we look at that other case, Unite Here, Local 5 versus City and County of Honolulu, better known as the Kuilima case. What is the rule that comes out of that case to your understanding?
Right. Okay. So the Kuilima case was the supplemental environmental impact statement case. In that case, Kuilima submitted a subdivision application, and that triggered the question. And then the plaintiffs in that case demanded a supplemental EIS. The developer argued that the project has not changed. Okay, the project scope, the elements do not change, therefore a supplemental statement was not required. The plaintiffs argued that, well, 20 years passed, so, and there was change circumstances, there's new evidence, and because of that, you need to do a supplemental EIS. The court agreed with them. Okay, and the court said, when you look at the rules, a change in timing is a change to the project. Okay, so if you have a change in timing, yes, your project's changed. Okay, that's the first part of a two-part test. Okay, in determining whether or not you need to do a supplemental statement. Okay, so if you have a change in timing, you have to move to the second part of the test, which is there, okay, because of that change, is there a significant effect because of that change? And in the Kuilima case, the plaintiffs were able to provide evidence that there was increased traffic. There were potential impacts to the monk seals and the green sea turtles. Okay, so, and this was new evidence that wasn't considered back when the original EIS was accepted. So the court said, number one, there was a change in timing. Okay, so now, and number two, there's a significant effect or impacts as a result of that change in timing, because the plaintiffs were successful in providing evidence regarding those three new facts: increased traffic, monk seals, and green sea turtles. And that's the rule we live with today.
Okay, and just so that we're clear, we're referring to the case Unite Here, Local 5 versus City and County of Honolulu, which is found at 123 Hawaii Reports 350. I'm sorry, 150, a 2010 Hawaii Supreme Court case. Well, Mr. Tabata, then let me ask you this. What is the evidence in the record that indicates that the Land Use Commission need not require supplementation of the environmental impact statement if you apply the rule from that Unite Here Local 5 case? What is the evidence in the record that you contend shows we don't have to apply the requirement for supplementation of the EIS with respect to the motion that you have filed here?
Right. No. Okay. So the first part of the analysis, I think, would start with the whether or not there's an action. Okay. So 343 requires environmental assessments when you ever have an action that is one of the listed triggers: use of state county lands, use of state monies, wastewater treatment plants. Okay, any action, action is basically a project that proposes any of those things. You have to then do an EA if you don't have an exemption. Okay, so changing the date for infrastructure is not one of those listed triggers. It's just not there. But is it then an action? Is the motion an action? And we say no, it's not. We're changing the date. An action is a project where you're then doing an activity. In Umberger, the question is collecting aquarium fish an action? And they said, because there was a permit applied for with the DLNR to collect aquarium fish for personal and commercial uses. Court said yes, it's an action. I mean, it's an activity. They could harvest hundreds of fish, and the plaintiffs in that case claimed that, or asserted that they were depleting the fish in the waters. It was affecting their fishing. They were fishing for subsistence. And the court said it's an action because it authorizes the harvesting of fish. So an action is some activity, actually doing something, developing real property, collecting fish. Those are examples in the case law. In our situation, we're just changing a date. It's not an activity. It's important. We're seeking consistency, okay, between our MOU and this commission's order. But it's not an action. And if it's not, so if it's not an action, then you don't need to do an EA under chapter 343. That's, that's our argument, basically.
And this is my final question, kind of shifting back to the Kapaka analysis. How much burden would it place on your client just to have a qualified cultural consultant give like a one-page statement saying that the analysis that was prepared for the solar farm parcel can carry over to the Haseko parcel? I mean, how much of a burden would that really create? In other words, sort of like to expand or to bring into conformance the or clarify the scope of the prior CIA. How much of a burden would that be?
Well, I can't really, it's their money. You know what I mean? So I can't say, oh, that's nothing. I mean, maybe, I don't know what it costs, $20,000, $50,000, whatever. If the commission orders it, then we're gonna do it. Put it that way. And a supplemental EIS would cost a lot more. I think that would be a burden, financially. I think they could live with it if we had to do a Kapaka analysis. Yeah, I don't think, it wouldn't kill the project, but, it's another thing to do.
Okay. Thank you, Mr. Chair. I have no further questions. Thank you, Mr. Tabata, for your very good explanation.
Thank you.
Thank you. Thank you both. Commissioners, any further questions for this witness? Commissioner Ohigashi.
Mr. Tabata, I went to bed last night and I didn't think about anything, and I woke up this morning and I thought about this question that I don't know if it was answered or not, but to satisfy me. Are the temporary utilities that's being provided, will they run on the same area or use the same area or general
No,
as the permanent?
no,
And
no.
in my mind, I know it was addressed and I just, maybe I forgot, but I just wanted to be clear. The permanent
Mr. Kwan, I'll have to swear you in.
area and so for the record.
Hold on, was that Mr. Kwan, please state your name, affiliation, and then I'll swear you in.
Peter Kwan, Vice President with Haseko.
Do you swear the testimony you're about to give will be the truth?
Yes.
Please proceed, Commissioner Ohigashi. Restate your question.
Essentially, I want to know where the temporary and where the permanent will be.
Okay. Without bringing the map up again, we had showed the diagram that showed it was the yellow pathway, which was what we call Road Y Phase 2, which is the extension of the existing Ononui Street to the north. That is a pathway that we're going to install and build that roadway, which will be a major roadway a spine roadway within our development, but it'll take paved roadway access and all of the major utilities up to I guess that's the southeastern property line of the Department of Agriculture. That's the permanent path. So our plan, in the worst case, unless we can find a better alternative, is to bring the temporary potable water and temporary power from Ononui Street, the current existing termination of Ononui Street, which is just above the top of Rokunia Country Club, and run it to the east of where the pathway of Road Y Phase 2 will be, go up through our parcels B and C, which are two eastern parcels, because those are going to be developed later on. Find a pathway that will not conflict with any part of our development that we intend to construct by the end of 2028, which is when we're due to deliver their permanent utilities. And then once we get up there, we'll bring it in at the proper point.
So, and the permanent utilities, when they're brought in, would that mean the temporary utilities will be removed and return to normal, or they will be continued to be used?
Yes, once the permanent utilities are brought online, at whatever date that is, basically it would render the temporaries unnecessary and we would just cut it off and remove it.
Because we're talking about above ground construction versus.
Most likely,
in-ground
yes.
construction.
The temporary water line, we may bury it just so nobody's running over it. Maybe in a shallow trench, but it would just be, I don't know if you've seen it, they call it a Driscoll line. It's like a kind of heavy black PVC, kind of a flexible pipe. We're planning on using that to run it all the way up to the property line, but we may, shallow bury it just so it doesn't get run over.
And just a comment, Mr. Tabata, I view your motion as like a motion to continue, in that vein, that it's to add additional time to some things that you need to add that time. And I see it more as a procedural motion rather than a substantive motion. And I will be proceeding on that vein. And in a procedural motion, I believe that that it would make it easier because it's not a substantive motion to go forward. And I think you address it because in your argument or your memorandum that you filed, you seem to indicate that no hearing was necessary in this matter. And you made that.
Yes, Commissioner, I would agree with that. It's, we're walking a line, a fine line. It's procedural. It almost feels like housekeeping, but at the same time, it's not unimportant. And that's, we're here for a reason. And we're not going to ignore the commission's conditions and the deadlines. So we're taking this very seriously.
I understand that, and I just wanted to let you know that I've had procedural motions be very important too.
Yes, sir.
So I'm going to take a 5-minute recess, and when we come back, I have a few questions. So we are adjourned. It's 10:02. We'll come back at we're not going to adjourn. We're going to recess. It's 10:02. We'll come back at 10:10. That's 8 minutes. Okay, it's 10:12. We're back 10:13. We're back on the record. Are we recording? Thank you. We are recording. Mr. Tabata, I just have a couple of questions. Maybe they're related to what the discussion was, but I can appreciate that you're trying to clean the record here and get the dates to all coincide to reality. And that's what this motion is about. And yeah, I think it's housekeeping in some sense, but it's very important housekeeping. And I appreciate the fact you brought it forward proactively to clean the record up. But let me ask you about the delay itself. In any, it occurred during the period in which the whole world was consumed with COVID. Did that have an impact to the delay itself?
I'm not sure, Chair. Maybe Mr. Kwan can answer that.
Mr. Kwan?
I'm not sure I can answer that question. I've been responsible for this project since the beginning of 2023. There was another gentleman that worked for our company who retired at the end of 2022. So I stepped in and assumed his responsibilities from that point going forward, which is how I'm involved here with this project. We did continue our operations during COVID, especially our construction side. It did not stop any of our design work. During those years, 2020, 2021, we had actually started submitting our master plan submittals, drainage master plan, water master plan, sewer master plan, etc. So we were working on this project during that period.
Are you aware of any negotiations that were going on with DOA during that period?
I was not involved with that at that time, so I can't say. I mean, I could check and follow up later,
That's all
but
right.
right now, I'm not aware of any.
Okay. Mr. Tabata, a generic question. And it's just for my own, it's hypothetical. I know I'm not a lawyer, so I will defer to you and Commissioner Okuda to have your own conversations, and I'll listen in on those. But the question I have in my own mind is for a project, and this is not necessarily specific to this project, but for a project in general that undergoes a what I would call a significant delay, like 20 years or more, for whatever reason. Does that in and of itself constitute consideration for a Kapaakai analysis or an updated EIS or environmental assessment, just by virtue of the staleness or the length of the delay?
Okay, if the project goes stale for 20 years or some period like that, first Kapaakai, it, if there was not okay, how it would come up is there would be some kind of permit application, say a motion to amend, to change the use of the land. And um, at that point in time, a person may come forward and say, "Well, I have constitutional rights, based on Article 12, Section 7, and this developer should be required to do Kapaakai." They could request a contested case, they could intervene, and at that point, it would be a relevant issue. That's normally how it would happen. If or say it's a motion to amend, or the commission may say, you should do a CIA, or in that situation, I think chapter 343 would then be relevant too, right? And if, of course, if you do a EIS, a supplemental EIS, you're going to have to do an updated cultural impact assessment, and which would include a Kapaakai analysis. So that's all possible. But there's for 343, there's a two-part test. Is there a significant effect as a result of the delay, the time change in the project? So yeah.
So in this case, we're talking about a couple of year delay that coincided with COVID, couple of year delay that coincided with new personnel changes within ASECO, et cetera.
Hmm.
But in a situation in which all of that occurred over a much longer period, what you're telling me is there's a much greater possibility that events occurred during that time period, or laws might have changed, or people might find new things they want to protest about and come forward, and that in and of itself could trigger the need for a more detailed 343 analysis or Kapaakai.
If there's a permit application, discretionary consent, like a motion to amend,
Yeah.
you then have to look at chapter 343. Okay. If somebody comes forward and makes that request or demand that there be a supplemental EIS, or that they have constitutional rights that need to be protected, then you would then be obligated to address those claims. Yeah.
Yeah, fair enough. Okay, different question. Again, hypothetical, but not specific to this motion. In a situation in which a project, improved project, commenced and was, let's say, 75% completed. You can look into the solar project, for example. which is near completion. A lot of work's been done, a lot of money's been spent on the land already. And then there's a need, for whatever reason, to come for an amendment. Amendment in scope to add a well or whatever that hadn't been originally anticipated. Would that trigger in your mind what I'm referring to as a full-blown Kapakai analysis or potentially a 343? In other words, is there any consideration for the fact that the land has been developed, partially developed to a very significant degree?
And when the project's been developed to that extent, or then that affects the issue of substantial commencement. I mean, that's different. That's order to show
It's
cause.
different, yeah.
Right, so I don't think the fact of that partial construction, I don't think that negates the possibility that you may need, if they come in, like you said, for a change in the project elements, then that would be like a permit application,
Mhm.
right? And then so that raises the question, that's like the initial trigger, so to speak. Hate to use that word, but then you gotta look at possibility of needing to do updated studies, perhaps Kapakai. And again, it's normally situations where somebody comes forward and they say, look, that use that you're proposing at this time is going to impact my my rights. And at that point in time, then they may need to do an update if they haven't already done one that covers that right being claimed.
Okay, I don't have any additional questions. Thank you for your
Thank you.
opinions. Commissioners, anything further for Haseko at this time? Hearing none, we'll move on to Ohana.
Chair, Commissioners, Ho'ohana Solar has no opposition to what Haseko Royal Kinea is requesting. We wish them the best of luck with this project. We've had a cooperative arrangement with them, or cooperative relationship with them on doing the installation of the non-potable water line. And I'll just leave it at that. We wish them the best of luck. We have no opposition to the motion, and I'm happy to answer any questions that any commissioners may have. Thank you.
Thank you, Ms. Lim. Commissioners, any questions for Ms. Lim? Commissioner Ohigashi.
I want to confirm for the purposes of the record in this case, because it was just stated in the last case, and I want to be sure that that your portion of the non-potable water line has been completed and is now able to serve the parcel in question.
Thanks, Commissioner Ohigashi. So I confirm that the non-potable water line has been installed. The grant of easement has been given to Department of Ag. It's ready to go. So Ho'ohana's obligation under the 2021 order, condition B1, has been satisfied, except we have the ongoing obligation to maintain the line, like we discussed yesterday. The line itself is not currently being used operational. Thank you. My understanding is because Haseko has yet to put the pump, which is, their obligation under the 2021 order, condition A1, to do that infrastructure, but the non-potable water line's has been complete since September of 2023, I believe.
And just to follow up with Haseko, is that pump going to be installed prior to December 2025, or is it?
The
This is Mr.
schedule is to complete, Peter Kwan. The schedule is to complete the installation of the mechanical pump and power connection and have the system up and running by the end of August 2024. So the water line pipe was put in last, I want to say August and September, by our contractor. We had kind of jointly contracted a local contractor to construct this project. Ho'ohana's responsibility was to install the piping, the 12-inch piping. Haseko took the responsibility of installing the mechanical pump, electrical connection, and there's a smaller 4-inch strainer line that also has to be installed. So all the piping has been installed. The mechanical pump, unfortunately, was kind of a long lead item. So we went through submittal process with the contractor and our consultant. We got all of that cleared up by the end of November and got all the parts approved. Contractors started ordering their materials in early December. Parts have been arriving since February. It's a mixture of mechanical pump components and some electrical equipment as well. The last of the materials are scheduled to arrive by mid-May. We have also already had HECO on site. There were 2 existing wooden utility poles that had to be replaced. It took a while to coordinate that with HECO, but they actually did come in February and did take care of that. So that part has been completed. The last step we are actually waiting for is clearance of our building permit for that electrical connection from those poles to the mechanical pump. But we should have that concluded by the time the last equipment arrives. The plan is to have our contractor remobilize once all the materials are here and have their electrical subcontractor and mechanical subcontractor install the pump equipment, all the underground electrical, including the concrete pads for the equipment, and get the system up and running so that we can turn everything over to the Department of Agriculture by the end of August.
Thank you very much. Thank you very much. I just wanted to be, I want to be sure that we have sufficient evidence in this record versus yesterday's record to make sure that we can proceed in this case. So getting back to Mr. Tabata's analogy or statement, 1 out of the 3 things is close to being completed. Is that right? 1 of the 3 requirements you.
Right,
Sorry.
the irrigation infrastructure, correct?
Commissioners? Nothing further. Thank you, Ms. Lim. Mr. Lee, representing our K2 partners.
Yes, our K2 Partners has no opposition to Haseko's motion. However, as I had discussed yesterday, we do have some issues and potential disputes to work out with Haseko relative to the timing of certain other infrastructure work that they committed to do under an agreement with us that we refer to as the second ARIA, the amended and restated infrastructure agreement. And so I just want to state for the record that we're not waiving any of those rights and claims.
Thank you. Commissioners, questions for Mr. Lee? Commissioner Okuda.
But Mr. Lee, you at least understood what I was saying yesterday, which is that these conditions run with the land. And so it would behoove all the current landowners to work cooperatively together, because if for whatever reason Haseko decides not to perform a condition which still runs with the land, your client might end up performing conditions which don't even deal with your land or your parcel, because the conditions run with the entire original parcel. So that's clear, right?
We understand that.
Yeah,
yes.
okay, thank you very much. Thank you, Mr. Chair.
Thank you. Commissioners? Okay, thank you, Mr. Lee. So Mr. Howell from Royal Kunia.
Chairman and members, Stephen Mao on behalf of Robinson Kunia Land LLC. Yes, we not only have no objection to the motion, we support the motion and would like to see the motion granted and the parties proceeding under the new amended MOU. Thank you.
Very well. Thank you. Commissioners? Thank you, Mr. Lau. Appreciate your being here and your comment. So we'll now turn to the Department of Agriculture.
Good morning, Kelsey Nagata, Deputy Attorney General. Department of Agriculture supports Seseco's motion to amend the 2021 order. If the commission grants this motion to amend the order, then the department will be able to build another agricultural park badly needed by local farmers. As previously stated, the department needs this agricultural park, including the operating infrastructure. The development of the Royal Kunia Agricultural Park will greatly help the department and was really important towards the department's goal of increasing agricultural self-sufficiency. Just to digress briefly based on what we discussed yesterday, the plans to develop agricultural park are shovel ready. Although the department is beholden to the legislature for funding to develop the agricultural park, this new fifth amended MOU greatly strengthens the department's position seeking funds for the park. Specifically, the bonding of the project and the accelerated timeline of the temporary infrastructure are incredibly strong arguments for the department to leverage additional funding in its favor. Any delays in completing the infrastructure are not in the best interest of the department. And as previously stated, without the infrastructure, the department lacked any leverage with the legislature for appropriations. Thank you.
Thank you very much. Commissioners, questions, comments? Seeing none, thank you very much. So counties, city and county of Honolulu.
Hi, Pono Arias. The city does not oppose the motion, and the city, in fact, actually supports the motion. Thank you.
Thank you very much. Questions for the city and county? Seeing none, thank you very much. OPSD, Ms. Gato.
Allison Kato, Deputy Attorney General for OPSD. And as stated yesterday, OPSD supports this project and also supports petitioners' requested amendments, which reflect the agreement between DOA and Haseco regarding condition A1. The intent of that condition was to benefit DOA to support agriculture and was based on the MOU between them. So it's appropriate to extend the deadline to conform condition A1 to reflect the current agreement, which would allow Haseco to move forward with providing temporary utilities with bond requirements to DOA for the Kunia Ag Park and also for the construction of much needed housing. The LUC has previously granted the same amendment of condition A1 to conform to this deadline before. As stated in our written submission regarding the commission's constitutional obligation and the Kapakai analysis, OPSD believes that granting petitioner's request amendment is consistent with the Kapakai decision. And to reach this conclusion, OPSD has conducted its own independent review of the available documents and information, which include, all the various documents that are available on the LUC's website and other locations, including the environmental documents, the cultural impact assessment for the solar farm, the DNO and subsequent amendments, and all the materials that the petitioner submitted as well, which include the reconnaissance level survey and the archaeological inventory survey testing strategy. Regarding the Chapter 343 environmental review, we just want to note that the evaluation of whether a supplemental EIS was needed was conducted by DPP in their evaluation 2021. And they issued a written determination that was published in the environmental notice that additional environmental review under Chapter 343 was not required based on the current requirements for an SEIS. After reviewing the environmental documents and DPP's published determination, OPSD agrees. I'm available for questions. Thank you.
Thank you, Ms. Gato. Appreciate it. Commissioners, any questions for OPSD? Seeing none, thank you very much. Oh, Mr. Lee, oh gosh, he has a question. He did his Columbo on us.
Colombo.
You are Colombo, yeah.
My, uh, my first comment is, you gotta get a better, signing pen on your agreement because the deputy attorney general is like a microscope. But the second comment that I have is that, do you believe that there's sufficient evidence in this record that we are not, that the land use commission can, or does not have to address the 343 issues as well as Kapakai analysis in its decision? And if so, can you please point to the evidence in the record so that we can have a good record or good decision if we decide to go that way?
Yes, so I'm hearing two different subjects. So the chapter 343 and Kapakai. Regarding chapter 343, the analysis of, and I think Curtis explained it earlier. The analysis for when supplementation is required, and looking at the two documents that are available, the one in 89 and 96, the EIS in 89 and the subsequent EA for the changed project in 1996. If you review those, DPP did a full analysis comparing those documents to the situation in 2021. And they issued a written determination that no supplementation was required based on that review. We have also reviewed the environmental documents and find that to be accurate.
Would it be fair to say, since if we did require a 343 analysis, that the Kapakai review would be as part of that 343 analysis? Is that right? A cultural impact review is normally this case, isn't it?
I mean,
So,
if one is required, it's normally in there.
right. So the review done by DPP in this case, you believe sufficiently supports a finding that such an analysis need not, a 343 analysis and including which would include a Kapakai analysis would not be necessarily addressed by the Land Use Commission in this particular motion?
The two issues are separate, but OPSD feels that they've been satisfied.
And the only reason I'm asking is I'm trying to figure out what in the record supports that position you take, because my understanding was that I like your argument, and I like Mr. Tabata's argument about DPP's analysis on 343. The question I have is, what in the record allows us to not consider a Kapakai analysis at this time? I'm careful with saying not consider, but because essentially, if we were to consider that, well, it's in the alternative argument. So that, because if we consider it, we may have to say why we're not requiring it. So I'm looking for evidence to say that we don't have to even consider it in our proceedings today.
Thank you for your question, Commissioner. I can elaborate. So the Kapakai analysis, the reason we believe it's consistent is, let me put it this way, the framework set out in Kapakai was created in the context of DBA, and as we've consistently stated, it's applicable in other similar types of situations, and other types of government actions. And we've seen the court modify this analysis to be appropriate to other types of actions, and that's the Flores case, which modified the analysis to be applicable to rulemaking. It examined the impacts to resources that may be caused by the rules that are being proposed. Similarly here, the current matter today is a motion to amend a deadline in a condition. It's not a new district boundary amendment. This is not a petition for district boundary amendment. This is a motion to modify a condition. So we think the appropriate analysis would be to look at the potential impact from this motion. And the documentation that is available currently, we believe, is sufficient to make that determination and determine that it will not have that kind of impact. And that's based on the various documents, including the 2020 CIA, which, while prepared for parcel 52, did look at the general area, including Seco's property. Also, the petitioner did have a reconnaissance level survey, which looked at the property and found that it went through over 100 years of sugarcane plantation use. And it made certain determinations that we think can indicate that this property, there isn't a potential for impact.
The reason why I'm asking this is that I think you're both saying different things to just about it. I think Mr. Tabata is saying that, hey, this is a procedural motion. We're not doing anything. It doesn't even require us to look into an analysis of Kapakai and the 343 analysis, because there's nothing in this motion that has anything to do with it. But in the alternative, he said, even if you do, we meet the test is, we don't meet the test that requires these analyses. Is it your position that the alternative argument that Mr. Tabata has proposed, is that OPSD's argument, or is it the latter, the first argument that's saying this is really a procedural motion? We're not doing anything anymore. We're just going forward with that. I'm just curious because when I read your paper, I wasn't clear whether or not you took that. And Mr. Tabata seems to be clear in his statement about saying that, hey, this is a procedure, but even if it wasn't, if it falls within this, that you have to take a look at. These are the reasons why. Okay.
Commissioner, you're correct. We are saying something a bit different, but we reached the same conclusion. OPSD is focused on Mr. Tabata's alternative argument, that we have reviewed the documents available that are in record, and we find that to be sufficient for purposes of this motion.
Do you agree then that his first argument is the position that OPSD would support?
We don't find it necessary, and we have not taken position on that.
Thank you.
Thank you very much. Any further questions for OPSD? No. Thank you, Ms. Kato. Okay. So at this time, Mr. Tabata, would you like to make any further comments based on the testimony of the other parties?
No, I think that's about it. Thank you.
So I'd like to have one follow-up question with you, Mr. Tabata. I find it in my hypothetical about when there's an extensive delay, what might trigger kapakai. And I think you said, I don't want to misstate what my interpretation of your remarks, so I might ask you to repeat them. That if a third party came forward and said that during this intervening period of the delay, that they discovered or they had issues, they could come forward and make the case, and that may trigger the requirement for kapakai at that time.
If the developer was coming forward with a permit application, like a motion to amend, then that would probably be a contested case hearing. So, I mean, my first argument is that kapakai is required whenever an agency does a, a contested case hearing or
Yeah.
rulemaking. So, yes, that could be, I mean, there will be a claim made. If there is a claim made that Article 12, Section 7 rights are being impacted in connection with a permit application, like a motion to amend, I think the commission needs to look at that situation. I'm not saying what the ruling should be, but yes, that it becomes an issue.
But in a motion to amend a condition, like in the case here, would that not also apply?
There's different kinds of motions to amend. I mean, if you're amending the project composition, you're changing the use,
I'm not
basically.
changing the use. I'm just got a long delay.
In this situation, when our motion is procedural and we're not changing the use, we're not affecting anybody's rights or privileges, our position is this is not a contested case hearing in connection with the fact that we did not request a hearing. Okay, so in our situation, it is not, because it's not a contested case hearing, it's a kapakai analysis is not required.
Understood. But we have a hearing and it's been agendized, and the public and third parties have had every opportunity to come forward and make a case and demand that we look at kapakai. It did not happen. Isn't that relevant?
Absolutely. If this would be another alternative argument. So if this was a contested case hearing, say you disagree, the commission rules this is a contested case hearing for whatever reason, you could then take the next step in the analysis and say, well, then nobody showed up to assert those rights, and therefore there is no need for a contested case hearing, or I mean, there's no need for a kapakai analysis, or maybe there's a second alternative argument where you do what the CJ wrote in Flores case Ohana, in that you apply the requirements of Article 12, Section 7 in a situation where there's no rights being implicated at all. So that in effect you're doing a kapakai analysis at that point.
You are.
And if there are, so this is like a second alternative argument. You do that analysis by noting that there's no implication whatsoever, and the analysis ends at that point. So in effect you've done a kapakai analysis.
That's my point.
Yes, you could just take it to that level and say, you know, even if there's all these even if it was required, even if there was a contested case, even if there was a person claiming rights, if we do a kapakai analysis as required, as described by Flores case Ohana, in this situation, because there's no rights being implicated at all, we can end our analysis at that point. So yes, you could take it all the way to that level.
Okay. Commissioners, anything further? Commissioner Okuda?
A follow-up question to the chair's question. The fact that no one shows up from the public or elsewhere and raises a kapakai issue, that doesn't absolve the government agency from not exercising its obligations under kapakai, correct?
That's a complicated question. I mean, the first holding in Flores case Ohana is that the plaintiff has the burden of proof to establish an impact to their Article 12, Section 7 rights. Okay, I mean, what does that mean, right? That means plaintiff or the intervener needs to come forward and properly lay the evidentiary foundation to satisfy that burden. At the same time, there's the public trust doctrine, right? Where you just can't be the umpire. You have to take affirmative action to protect rights like Article 12, Section 7. So like the chair noted that, okay, you can still do that Kapaa analysis. Okay, by looking at exactly what are they asking for in their motion. And in our situation where rights are not being implicated because it's basically procedural, we're just changing a date, you can complete that Kapaa analysis by noting that fact that no rights are being implicated or impacted. And therefore we can end the analysis right there. And that constitutes a Kapaa analysis.
But again, the fact that no one shows up doesn't, for example, absolve the Land Use Commission from exercising and complying with its obligations, for example, under the public trust doctrine, correct? I mean, there's certain things we gotta do because we sit on the commission, whether people are watching us or not watching us.
I don't know how you reconcile the public trust doctrine with the first holding in Flores case Ohana. The burden of proof is, they said it. They have the burden of proof. Okay, I mean.
Okay, I
So,
understand. No, it's fair. It's a
so
fair
that's an
statement,
interesting
yeah.
question because,
Yeah.
okay, so where the Supreme Court, Hawaii Supreme Court said, in, I think it was the Oʻahu water case, but the agency just can't be an umpire. You have affirmative duty. That was, the Water Commission made a ruling that well 7 did not need to be improved. Okay, I mean, in that case, the plaintiffs, the farmers were saying that, HCNS's surface water allocation should be decreased because they can increase the pumping at well 7, the groundwater. But HCNS said, but that's going to make us spend more money. It's going to have economic impacts, right? So the commission said, well, okay, we're not going to make HCNS make the capital improvements to increase pumpage because of the economic impacts, but nobody quantified those economic impacts, right? So the court said, you can't just assume that there's going to be economic impacts. You have to quantify. You need evidence. You can't just be an umpire and just, take the lack of evidence as sufficient reason. Okay, so in our situation, if somebody comes forward and makes a claim that their rights are being impacted, then and if there's a lack of evidence to absolve the developer, then perhaps there shouldn't be an assumption that the lack of evidence is reason to absolve the developer. But the fact that there's nobody here, right? Can you assume that there are people out there that are being impacted? I'm not sure if it goes that far, is what I'm saying. I mean,
Yeah, and no, I understand your argument, and I guess that's why there are lawyers to reconcile these differing cases. Thank you very much, Mr. Tabata.
thank you.
Thank you. Commissioners, any final comments or questions on the declaratory portion of this meeting? Commissioner Carr-Smith.
Thank you. Just had some common sense, non-attorney comments. I feel like all of the hypothetical situations that have been raised today are confusing the record a lot. It's hard to keep it all straight when we talk about things, what if, because I think that what we have in front of us is what we should be talking about. I think the petitioner stated that there is no legal trigger for this, and I believe that Mr. Tabata would say otherwise if that were the case. Changing a date does not affect anyone's rights as it relates to the case, Flores case. And just because the petitioner is cooperative and stated that they would be willing to do something, I don't think that that means that they should be required to if it's not the right thing to do, or if it's not required. And I feel like if we're going to start talking about setting precedent for insisting on Kapakai or 343 for changes of dates, that we're kind of setting ourselves up for some issues in the future. Those are my comments for now.
Thank you. Appreciate it. So given that the parties have finished presenting their cases and final arguments before the Land Use Commission, I declare the evidentiary portion of the proceedings have been completed. I'd like now to do public testimony and final call. So once again, are there any members of the public who wish to provide additional and or new testimony on the motion? Seeing none. So at this point in time, we'll enter into deliberation. And the chair will entertain a motion on how the commission should proceed in this matter. Commissioners, what's your pleasure?
Mr. Chair,
Commissioner Ohigashi.
I move that we approve the motion. We'll grant the motion.
Thank you. Do I have a second?
Mr. Chair, second.
Commissioner Yamani seconds the motion. Commissioner Ohigashi, can you speak to your motion?
Yes, I'm going to speak to it. I believe that this is a procedural motion and that it doesn't affect any rights or liabilities of any other parties. I think that there is good cause exists to adopt this motion. The good cause is essentially the fact that the agreement has been reached between the Department of Agriculture and Haseko Development in order to pursue or complete a long needed agricultural 150-acre park. And I believe that there is sufficient basis in the record to find that that Haseko's motion can be supported absent or does not require a 343 analysis as well as a Kapakai further analysis. I like, because this is comments, I'm going to make the comment that this is not the case for all just changing dates. As the chairman has indicated, and in his questioning, if we have a 30-year project that's been sitting idle, the changing of the dates becomes substantive. So I'm limiting myself to this motion. I'm limiting my comments to this particular motion with this particular development under these particular circumstances. And I see the need for future, and I see the need for future discussions as to changing the dates, issues regarding long-term, what would we say, long-term projects that have not been developed for any reason.
Thank you, Commissioner. Mr. Yamani, you want in support of your second?
Thank you, Mr. Chair. First of all, I'd like to extend my appreciation for all parties. This started really complicated, and it got a little more convoluted with the hypotheticals, but to me, the ask is simple. I'm not a lawyer, I'm just an engineer here, but listening to the request, it's a simple request. I think it's a practical request and appreciate that the petitioners did come forward. In my mind, I would fully support of this motion to grant this change in date. Just, to me, it just makes sense. And, I think we've talked about it enough. Thank you, Mr. Chair.
Thank you, Commissioner. Commissioner Okuda.
I'd like to make a request first. Among the various commissions, the statute specifically requires certain commissions to have a cultural or designated cultural commissioner because of the potential impacts on Native Hawaiian practices, resources, and the other items that are required for protection under Article 12 of the Hawaii State Constitution. So if he doesn't mind, I would ask Commissioner Kamakea O'Hello to give us some of his thoughts right now, because that would or may affect what I would decide, and I would make that request, Mr. Chair, if the commissioner is willing to do so.
I will forward your request to Commissioner.
Mahalo, Chair. Mahalo, Commissioner Okuda. And I just want to mahalo everyone here today. You know, it's been a bunch of hypotheticals. And as I'm not trained in law in any way. However, I do receive and acknowledge that the motion is very simple, an extension of time for alignment. However, I must say, and if I could just please place it on the record, if it pleases you, Chair. In my personal capacity, and in my professional capacity, I've witnessed, CIAs be insufficient in the past. And I've actually experienced CIAs be weaponized, against communities, especially targeting Native Hawaiian communities. So while I do recognize that the evidence, should be sufficient in this case, and the motion is very simple. A kapa'akai analysis should not be limited to physical structures on land. And I'm going to give them an example. In 2019, 2020, the community of Waimanalo was up in arms against the city and county of Honolulu at Waimanalo Bay Beach Park. Through their master plans, they also had a CIA, and they leaned heavily on that CIA. And their statements were from the county's administration at that time was there is in fact no iwi kupuna, there is in fact no cultural significance to those spaces. When in fact, Waimanalo Bay Beach Park was previously part of the Bellows Air Force archaeological site. In totality, 1,200 acres, which is still the largest landmass on the federally recognized historical places. So in their when they resumed constructions within 3 hours, they found iwi kupuna. And that's in fact what stopped the project today. So I just want to say, it's not just about the physical, evidence of what our kupuna of yesterday practiced and where they lived and how they lived. It's really about the pilina relationship between the Native Hawaiians and their Aina. And I just want to point out, I've heard it iterated many times today that these are, in fact, previously farmed sugar lands. And in the 1920 Hawaiian Homes Commissions Act, it clearly states, as well as it's reiterated in the 1959 Admissions Act, as well as in the 1978 Constitutional Convention, that 30% of all sugar lands and the water leases attached to, are set aside for a fund for Native Hawaiians, as identified in the 1920 Hawaiian Homes Commissions Act. So this, in fact, impacts Native Hawaiians as a whole, as a lahui, as a nation. So again, I will recognize that today's motion is very simple and an extension of time. However, please, for the record and on the record, in the future, consider, all decisions and all acts for the Land Use Commission. So mahalo again, Commissioner Okuda, for calling me out. I yield back, Chair.
Thank you, Commissioner Kamakea O'Hello, for your remarks. So back to you, Commissioner Okuda. Any follow on?
Yes, taking into consideration the statements of the designated Agricultural Commissioner. I do agree that the petitioner here, Haseko, has met its burden of proof. I believe a common sense reading of that one sentence that I read from the Kapa'akai case about the fact that a Kapa'akai analysis or requirement is triggered by an act or action of the government agency requires a common sense, plain English interpretation of the words. And I agree, and I would find, based on the discretion given to the Land Use Commission and as a government agency, I would find, as a matter of fact, that what petitioner Haseko is asking for at this point in time does not constitute an act or an action as stated in the Kapa'akai case, taking into account the caveats and warnings that the cultural commissioner has reminded us all on the record. For similar reasons, I would also find that at this point in time, any requirements of supplemental environmental assessments is not required under the Unite Here Local 5 versus City and County of Honolulu case, because the actions being requested is simply an extension of time. And finally, to be consistent with what the Land Use Commission did yesterday in finding that no further action need be taken with respect to otherwise potentially delinquent status reports and items regarding deadlines, to be consistent with that. This is simply an extension of time, as Commissioner Ohigashi has stated. So recognizing the fact that the Land Use Commission under Kapa'akai and the Flores Ohana case cannot delegate its obligations, even taking into that account, I believe that the evidence supports the granting of the petitioner's motion. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Commissioners, anybody else like to speak to the motion?
Chair, I don't want to speak to the motion, but I just want to make a comment and a statement. You know, I guess after we leave today, we're all going to get a certificate on section 343 and the Kapa'akai analysis. But I believe that this housing that Haseko is going to be looking at building is long overdue. We got a lot of Native Hawaiians, a lot of locals that's moving up to the mainland. In fact, a survey was done. We got over 15 to 17,000 Native Hawaiians moving up to LA, up to Las Vegas and other parts of the mainland. I think this project is long overdue. It's going to provide many affordable housing units. And of course, I believe it's going to be close to 1,400 total units that's going to be built in this area. Let's get RK2 going. Let's get that ag park going. And I believe this project is going to be very helpful for the people here in Hawaii. Thank you.
Thank you, Commissioner Kahele. Commissioner Carr-Smith.
I just want to go on the record saying that I support the motion. Thank you.
Thank you. Anybody else? So the chair will support this motion as well. I commend the party, Haseko, and your council for bringing the motion forward. I would not have been surprised if this project would have continued and we'd have learned about it after the fact. So I do think that it's the fact that you are showing respect for the importance of this motion and to bring it for us is very much appreciated. It's the right thing to do. At the same time, I think you've heard that it's a kind of a common sense consideration that we're applying to it, that it's a delay or you're missing of a date in condition in the condition that is explainable, understandable, and not consequential in terms of its potential impact, its impacts. And I appreciate the positions taken by the other parties, including the OPSD and the Department of Agriculture. in support of the motion. That's important to me as well. I also want to reemphasize a point made by Commissioner Ohigashi his remarks at the ending of his remarks, which is this is not a precedent in my mind that says if there's a delay, we can fix the delay and it's not consequential. But if that delay is long-term, 20 years, 30 years, 40 years, and in particular, if there wasn't any substantial development on the project in those years, what we're doing today does not affect that. That would be a totally different set of circumstances, and I would expect a totally different result. Mr. Orndecker, please take a roll call vote.
Thank you, Chair. The motion is to grant the motion to amend. Commissioner Ohigashi,
Aye.
Commissioner Yamane,
Aye.
Commissioner Okuda,
Yes.
Commissioner Kamake Ohel, Commissioner Lee, Commissioner Kahele,
Aye.
Commissioner Carr Smith.
Aye.
Commissioner Atta,
Aye.
Chair Giovanni.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Commissioner Ohigashi.
I just have a short comment. I'd like to thank Commissioner Okuda. He placed on the record to make sure that our decision should not be scrutinized in any other matter. And I commend him for placing these issues on the record, so we have a record that we can rely upon when making this decision. And I will miss that from him. Thank you.
Thank you, Commissioner. Parties, I have some requests relative to the proposed decision and order. If any of the parties desire to stipulate to any portion of all the findings of fact, conclusions of law, and decision and order, you are encouraged to do so. If you desire, you're encouraged to do so. Regardless of whether the parties pursue a partial or stipulated order, each party is directed to file its proposed findings of fact, conclusions of law, and decisions in order with the commission staff, and to serve copies on the other parties no later than May 15th. That's this is an option you have. It's not a requirement. That concludes the business on the ninth order of business for this. So I will take it's now 11:13. We're going to take a recess. It's too early for lunch. We're going to do something else. Are you hungry? Yeah, okay. We're going to it's 11:13. We'll take a recess to 11:25. Okay, is the recording back on? It is. I am reconvening end of recess. We'll reconvene the meeting. And our 10th order of business is the introduction of the Land Use Development Coordinator, member of our LUC staff. Mr. Orndenker, please proceed with the introduction of the Land Use Development Coordinator.
Thank you, Mr. Chair. Arnold, stand up, Arnold Wong is our new development coordinator. And this is actually an exciting, and we think long-term, hopefully solving a lot of problems that we've had with developing housing. And what we had discovered in review of our records was that there are approximately 440,000 to 65,000 housing units that were promised that are unbuilt on various projects all around the state. So what we decided to do was to venture into a new program, a new activity for the Land Use Commission and hire someone to go out and find out why these projects aren't moving and what can we do to help them move, to be proactive in trying to get units built that we'd already approved. I think that we all recognize that if we could build 45,000 units in the next several years, it would make a big impact on housing. We hired Arnold to take on this role in part, not only because he had a good understanding, being a former commissioner, of how the commission works, but also because he has a good understanding of how the private sector works and the legislature works. He has good connections in state and county government, and he was the best candidate for the job out of all the people that we interviewed. This position, or what Arnold is going to be doing, is basically shaking the trees to see if he can work things out. We've already had some successes. And not surprisingly, we found that one of the biggest problems is us, and I mean, when I say us, the state. There were certain things that were just not getting done for various reasons. For instance, agreements with the Department of Transportation. Nobody knew what to do about some of our conditions, how to effectuate them. For instance, the requirement to build a what do you call it, emergency siren, and dedicate it over to HAIMA and things like that. It's been fun for the past several months. Arnold came on in November. And he's already had, like I say, had a big impact. Not surprisingly, Maui was the first island we reviewed because of the sudden need for more housing. Arnold immediately had success in helping to facilitate a backlog of 3,000 homes. And I can be specific, a little bit more specific about that. We're working with state and county agencies to ensure that we can get these projects built. We've established a working relationship with Commission on Water Resource Management, HAIMA, HHFDC, and DOH, to name a few, that now allow us to work with them, to help with developers, facilitate with developers to get things moving. It's contemplated that if some of these developments require amendments to the decisions and orders to move forward, that Arnold will help bring those to the commission. Maybe not necessarily present them, but he will help in facilitating the developers to come forward and resolve the problems. We've started looking at other counties as well. Right now, we're looking at 1, 2, 3, 4, 5 projects on Kauai that could result in several thousand units being built. On Maui, we're looking at 4 or 5 projects. We're looking at 1 project on Lanai and 1 project on Oʻahu. And that's about, we add all those up. If we have success with those projects, we're looking at about 10 to 15,000 units. I just wanted to bring Arnold here and explain to you what we're doing, and see if you have any questions for us.
Thank you, Dan. Arnold, did you want to say anything?
Thank you, Chair. I just wanted to say thank you to the commission and the executive officer and the staff for allowing me to take this position. It's been a different, being on this side of the mic has been very different from being on where you guys sit. So I just wanted to say thank you, and it is a learning experience for me also, but thank you.
So do you mind if we open it up to questions from the commissioners for you or for Dan?
Please, Chair, it's your preference.
Okay, commissioners, any comments, questions? Commissioner Carsmith.
Thank you. So Executive Director, you didn't mention Hawaii Island.
We're beginning to work on that. You know, it's only been a few months that Arnold's been here, but we will be working on Hawaii Island as well. The Oʻahu project, we weren't even really working on Oʻahu and somebody brought it to us. The Kauai projects are a result of our conversations with Kai and Hull on other matters. And, you know, he brought up these projects that weren't moving. But Arnold's real heavy work and his heavy lifting has been on Maui right now for obvious reasons, but we will get to the Big Island. for sure.
Understandable. I just wondered if there was a reason that you left it out.
No.
The only other question I had is you said that you had had some good success recently with this already. So I was wondering if you could speak more to that.
Thank you, Commissioner. So what occurred is, as the executive officer said, we were looking on Maui, especially closer to the Lahaina area. And, you know, Kihei, et cetera, because it's closer on that side of the island. We were looking at different places outside of Lahaina because of all the issues with the water, you know, all the dust and everything else. So we looked at one project in Kihei, and pretty much it was close, really close to shovel ready. And the issues was pretty much as the executive officer said, in Kihei, it had the Haima problem. Haima and the developer just stopped talking for a reason. So we facilitated the discussion again. I can say for a fact that Haima went this last month on the 19th to try and pin where they should have a emergency siren. So that has been done. So that's pretty much, they're gonna shovel ready, because also the DOT memorandum has been been working on, but sorry to say, as we know, different attorneys have different styles of thinking. So it has been slowed down, but it's in progress to be signed, like by the end of the year. So it's, if not sooner, I would say in a couple months that the MOA is gonna be done with DOT.
Yeah, the specific projects were Lipoa, McKenna, and we were working very hard on Pulelehua for a while. And this is one of the things that we think is valuable. Arnold's activity is valuable. Pulelehua stalled because of the water situation on Maui. And so Arnold has been in, both of us actually have been in conversation with Commissioner of Water Resource Management, bringing to their attention, so to speak, that this issue needs to be resolved, and that pointing out that they're holding up 3,000 units until they do, and trying to stimulate some activity, I guess is the best way to put it. Well, it's a special management area for water, and there are a lot of demands for that water right now. Before the fire occurred, there was a cap on how much water could be taken out of that particular water management area for things other than, for lack of a better word, downstream cultural activities. It's different from other areas. Once you designate an area, you have to get permission from the Commission of Water Resource Management for any allocation. And there's a limitation on diversion of groundwater. So it gets complex because with what FEMA is doing and the temporary housing, there's a restriction that they're chewing up a lot of the allocation that's available. Let me put it that way. And that's only temporary. And so all the developers, potential developers of housing on Maui are not now clamoring for either what's left or what is going to happen with that allocation Once it's done, can they get a piece of it? It's almost, it's very ironic because it's almost like a gold rush.
So let's take this project. When this project was approved, weren't the water issues addressed up front as being adequate? And
Are you for Halekua or for the project today? The whole on.
no, the pool.
Yeah, pool. Well, yes and no. You know, Arnold, why don't you speak to?
Yeah, so the Pulelehua project was interesting in the fact that they did not apply for with the Commission for Water Resource Management for a permit to use water. But also they were thinking of tapping the county's water supply, so it's an existing permit. However, the county has maxed out their allocation, so it would be either a new well or a new tap on the groundwater. There's two different water supplies, and new permits will take a longer time than existing permits. So that's the reason that Pulelehua has been stalled.
So what's your advice to this commission when a project comes before it and water is needed for the project to be successful? What should we require the developer when they're coming before us?
So the good thing about my job that the executive officer has been sitting with us with the and also Mr. Derrickson is that we have met with Commission on Water Resource Management, and we have opened a better, I shouldn't say a open dialogue in terms of our projects to say if someone comes in, we want you here at the table at the beginning of the stage, not to know that this is coming up and what do they have to do, tell the developer what they have to do. Not what do they have to do in hindsight, but be proactive.
If I can speak to that, Chair, what happens, staff requires the developers when they file their DBAs to show that they have water, right? Very often what happens, or sometimes what happens is their assertion is that they're going to drill a well, or they're going to, even if it's off-site, to provide water to the project or to replace the water they're going to take out of the county system. Sometimes the projects that come before us simply say, well, the county's given us an allocation of X, and in most cases that's sufficient, but sometimes, like what we're seeing in the West Maui situation, is that all of a sudden something changes and that allocation is no longer there, or it's insufficient. We've been struggling to develop a relationship between Commission on Water Resource Management and the county boards of water supply to get them to talk to each other more, so that county doesn't make a representation that they have water and then all of a sudden they find out that they don't. So what we're doing is kind of breaking down barriers.
I appreciate that, but but from a practical matter for a particular developer, it's one thing for this commission to be attempting to make decisions with uncertainty about water allocations, but I can only imagine what that uncertainty presents for the developer themselves. So this seems like I appreciate you're trying to unscramble the eggs after they've smashed and you've got problems on a project, but to the extent these things could be addressed, and I guess you are in some extent up front.
Yeah, that is what we're working on, is to have Commission on Water Resource Management work more closely with developers to.
Yeah, Mr. Ogashi.
Yeah, I just want to compliment our executive officer and Arnold. Commission made a decision long time ago, or few years ago, or even yesterday, or let's say to grant DBAs. And leave that to themselves. And according to our numbers, it's between 40 and 60,000 units that are being developed. So we get all, everybody says, hey, LUC, you are holding up development. When we have 40 or 60,000 approvals for housing already on the books. Our problem is we don't have enforcement powers under Virginia Lea case. We don't have, we can't do it. We can't go and go out there and force them to get a bond or force them to do anything once it develop. Once it develop. So this is the next best way, is to try and utilize the commission's resources or to try and get them to see how they can comply. The problem though is that if we are working with them, it's maybe more difficult to bring, well, the problem is how far can you work with them, and then to taint them filing for motions for subsequent changes to their DBA. So it's good that you guys are doing this. It's great, but I'm hoping that once that this results in positive things, rather than a flood of new new amendments to the existing motions. Because if we have like one of the projects I know is like 20 years, up to 20 years, yeah. And
if I can, Commissioner.
you have a, but those are the times we want to get started. No, and that's all I wanted to say, that you guys are doing. I think this is the second best way that you can do it, because we don't have any other power.
Yeah. Thank you, Commissioner. I appreciate that. One of the best examples that we have of what is being done without having to involve the commission concerns one of the projects on Maui, where we discovered that our requirement was for the condition that was contained in the DNO was for the developer to resolve the roadway improvements. And the way that the condition read was with the approval, by approval of DOT. It wasn't like they already had a plan when we did the DBA. And what we discovered was that DOT had told the developer that, oh, don't worry about it, we're going to build it. But then they stalled. They never entered into the agreement. Yeah. And so, by pushing a few buttons, we were able to get DOT to move on that MOA. And, it's that type of thing. I mean, I don't think that our experience so far is going to implicate the commission all that much, because as you pointed out, there's a limit.
I think that you shouldn't get involved with any commissioner on that particular island doing these things, because that would taint them coming to the commission. And so I think that this type of activity that you can report to us is the best type of activity versus some direct involvement with the commissioner going over there and saying, hey, you guys gotta do this and do that, and it taints the subsequent, if you have to modify a condition or something like that in the future. That was my only concern. And what can we stick on Marquis School? No, I'm
Commissioner Okuda.
Yeah, I think this is a really good idea. I think on one of our trips that we took to a planning conference where we actually attended, the conferences and we don't just waste taxpayer money. This was a type of thing that was suggested, almost like a concierge, where you get people together from various agencies to just get the nuts and bolts done. And the fact that communication or just being in the same room does really good things to moving, projects forward. At the very beginning when Governor Green was elected, a person from his housing task force contacted me and I put together a short memo, which I'm sure was ignored. But one of the things in the short memo to get housing going was doing something that you're doing here, which is just get people in the same room and find out what has to be done. And as the chair always says, since he was the operations guy at Hawaiian Electric, if you're going to get something done, just go get it done. And so, I think this thing about just getting it done, gets it done. So I think it's a really good idea. Good for the community.
Commissioner Lee.
Thank you. So I want to make sure that Arnold doesn't get distracted by too much manual labor or other duties from his primary duty, although lunch is okay if you want to bring lunch. Have you detected so far any consistent themes for some of the delays? I know you've just started doing this, but interested to hear what you think.
Not really. Each docket is different, and so it's just looking at the docket and seeing what is the problem areas. So each one has a different issue.
And so you're not just restricted to working with other state agencies like CWIRM, you'd also be tasked to work with county agencies as well?
Yes, Commissioner. So we, for example, the Maui one, we did work with the Department of Water Supply.
How about nonprofit and public groups?
We haven't come to that point yet. But if, let's say, for example, Habitat or as a nonprofit or private developers do come up in part of the docket, we will work with them.
I guess there's some potential liability if you maybe talk to certain groups and they feel that they're hearing certain pledges or commitments. So I guess there's some places to be careful about. Is that correct?
Yeah, yes, Commissioner, we're very well aware of that, and I've counseled Arnold that we don't make commitments, we just bring people into the room to see if they can resolve the problems between themselves.
Yeah, and one last thing. I have heard some wary comments that they hear from someone from the LUC, not just Arnold. It's like the cops asking you, so what are you doing? Just be prepared that there's that dynamic. Thank you.
Yeah. Commissioner. Hello.
Hello, Chair. I guess my question is either for Arnold or the executive team. How often will you be reporting to this commission?
That's up to the commissioners. I mean, we can make it a monthly or couple of months. Things don't move that quickly, so I would suggest 3 or 4 months in between report to.
I would suggest quarterly. It would be, depending on our meeting schedule, just agendize it every 3 months or so. Okay. That work?
Yes, Chair. I'd also recommend quarterly. As commissioners to stay updated on past and future projects, especially in the case of any Maui projects with the county Show Me the Water law. It's a lot of our dockets that come through and a lot of the decisions we make is very human centric, but the very title of our agency is Land Use Commission, and we also need to take into account, right? I know or land centric, right? And if in fact, future projects cannot, if aquifers or water systems does not currently have the sustainable draw, right, then we need to be informed as commissioners what that looks like for future sustainable developments. So mahalo.
Commissioner, who is that? Kahele down there?
Yes, Chair. Are we on record?
Yeah.
Oh, shucks. Actually, I just wanted to make several comments about Arnold. He and I worked together for the Ironworkers Stabilization Fund for 20 years. And he and I had some accomplishments while we worked with the legislators, with the governor, with the mayors. And he's always been a professional. He always got the job done. He was straightforward. And if he wasn't able to complete whatever assignment, he always asked for help. He's been a chair for the Land Use Commission at one point in time. And for me, I don't believe I have any concerns about Arnold fulfilling his duties as the development coordinator.
He is a Dodger fan, you know.
Yeah, but too bad we're on record. Shucks, if we wasn't on record, I would have had some better words, but Arnold, congratulations. I'm happy for you.
Yeah, he wore red just to hide the fact that he's a
Thank you,
Dodger.
Commissioner.
I have a different question, I love the process that you're being proactive and you kind of target a project or two that you know, whether it be on this island or that, where you've heard and you start digging, right? But as it becomes known in a broader audience that the Land Use Commission is doing this sort of thing to help move projects forward, I'm gonna put my hat on as a developer. If I'm a developer and my project is stalled for whatever reason, I'm this government agency or that government agency or this permit being stalled or whatever it might be. Do you think it would work that they would have an opportunity to contact you for assistance?
That's what we hope for. I mean, we want it to be that we are here to help the developers for the people of Hawaii. That's the main thing. It's to ensure that the people will get housing.
Then we need to get the word out
Yes, and I
at the
think
appropriate time and
Yes.
et cetera, you know, and it's usually best to do that when you've got a couple of successes in your pocket that you could show the type of thing that you can accomplish.
yes, Chair, and we hope that through these successes, as you say, it will go out. I mean, couple developers have already contacted us to work with them. So thank you, Chair.
Well, I think to, you know, the Commissioner O'Hello's request, the fact that it's going to be a regular part of our meeting on a quarterly basis, that in and of itself will start propagating the understanding that we're here to serve and do this function. And I think as part of that, we could, when you're ready, help, I hate to use the word advertise, but advertise that we are available to help.
The good thing about this, Chair, is we already started talking to, as you see, some of the attorneys
Sure,
here.
sure.
So they already know it and they can talk to their clients if they
Yeah,
need to be.
yeah, it'll grow in time. Good.
Thank you, Chair.
Commissioner Otta.
Yeah, I'm thinking that's good to be responsive for the developers, but I hope that you do some research about with each of the county planners, and among them especially the long range plans, so that you folks know. But the cities, each county has a long range plans. And that I think the Land Use Commission should be very close with the people on the county that are looking forward. And I mean, I knew Steve Young was working at Oʻahu, and he looks for 10, 20 years in the future, and that the Land Use Commission should be working closely about what we anticipating in the 10, 20 years for, and that you folks will be working with them a lot.
Thank you, Commissioner. Yes, we have started that discussion, And it has been very fruitful, and we are working with different county agencies at this time.
Commissioner Yamane.
How did you know I wanted to talk?
Lean forward.
I just had a question for you, the Executive Officer Arnold. I'm assuming you're working off of a list of projects that have the dates of the DNO, number of units that impacted. That's kind of an exciting list. I wouldn't mind seeing that in the quarterly reports.
Well, we'll give you what we're working on. Some of what's happening is that Arnold is digging into the DNOs to find out which ones haven't moved. So we don't have a list right now, but as we dig into it more, we can bring that forward.
Yeah.
Thank you. Just a message to my fellow commissioners, as Commissioner Oigashi mentioned, we as commissioners got to be careful. We can't get involved, but on our respective turf, we do run into people know we're commissioners, and they know we're land use, and the questions might come to us, and they do come to us. Hey, can you help with this, or can you help with that? And generally we say we can't get involved because of this or that. But is there any problem in us steering them to you?
Chair, no, I mean, we open dialogue with anyone to help facilitate projects.
Right. So to my fellow commissioners, when you get tapped on the shoulder or someone asks you about a project, you may or may not know what the issue is, but certainly there's no hesitation on your part that should be in place. You should refer them to Arnold, right?
That is correct, Chair. And, I mean, I'm going to say truthfully that without the executive officer and staff to help me and guide me, I wouldn't be able to do things. And the commissioner, they helped me a lot to just get up and running to this point. And I hopefully with help we'll continue this process.
I'm sure that will work. Is there anything, this is to you or executive officer, is there anything as a commission or as commissioners that we can do to help the process?
I'll be very blunt. I would hope the commissioners would stay out of this. I don't want to run into a situation where a commissioner is compromised as a result of being involved in what Arnold is doing. We actually have somewhat of a Chinese wall set up in the office. I mean, I talk to Arnold on a regular basis, and he gets assistance from Scott and Martina when he needs to ask questions about a DNO, but I'm not involving Scott and Martina in any of these. I think that the more separation there is, the better it'll be.
I think you're right, but let's dig a little deeper here because, we just kind of concluded that if a commissioner hears about something, he could refer it, but he's got to respect that Chinese wall, right?
Well, our standing advice is
Not Chinese, not in your sense, but
ethical
ethical. It's a firewall.
I'm sorry.
Yeah, you call it Italian wall if you want.
Whatever. As we've said in our orientations, if anybody approaches a commissioner about a potential project, proposed project, a project that's going to come before us, or a problematic project, they're to just refer them to myself. I mean, that's not new. So it's the same thing. The difference now is that a commissioner can say, why don't you call Arnold, because he can probably help you.
Anything further?
Chair, just briefly. Yeah.
Mr. Smith.
I just wanted to comment that I'm glad that you are the one that's here doing this. I commend the staff for wanting to improve relations and appear to be trying to be cooperative with petitioners and find out why things have stalled. I can't help but think of a couple of meetings that we had in Kona, and those were long stalled petitions that had new owners and coming before us, and I didn't see a lot of cooperation on those levels. And so I'm not sure how this is different. If we're not doing all we can to help people be successful in the meetings and the petitioners that come before us. But yeah, we're trying to go back and find old ones. I'm not sure I fully understand that, but I wish you great success and I'll look forward to hearing.
Thank you, Commissioner.
Yeah.
Okay. Anything else? Anyone? Thank you, Arnold. Welcome aboard and glad to see you going full speed again, buddy.
Thank you, Chair.
Yeah, and thank you, Dan, for making this happen. So with that, I'm going to call a lunch recess. It's now 12:03 and we'll be back at 12:30. Ariana, are we back on the recording? Thank you. So it's 12:31 and we're back in session. So the next agenda item is the discussion on the protocol for legislative testimony and monitoring of legislative measures. So commissioners, I would like to have just an open discussion among us and staff regarding this practice of presenting testimony to the legislature on pending bills and the associated methodology. And my understanding is that there was discussion of this topic, inquiry of this topic at the last LUC meeting in which I was not in attendance. And so that was kind of the starting point of where this agenda item came from. And I think that Commissioner Lee, you were the one that kind of brought it up, if I'm not mistaken. I did have the opportunity to watch the recording that Ms. Kwan prepared for us from that meeting. So I'm kind of up to speed with that. But can you share with us just kind of take a half step back before we try to take a couple steps forward here?
Yes, thank you, Chair. I guess sometime prior to the last LUC meeting, some of us, we work with the legislature and we follow bills and measures, and different boards and commissions have different policies. I'm a new person here and I didn't know if we had a policy. It sounds like we didn't, or if there had been one, it hadn't been updated. And so I noticed that there was testimony on a certain bill that stated that the Land Use Commission was in strong support of it. And I thought, well, that's surprising to me because I don't think we took a position on anything. And I understand the circumstances around that and how time is of the essence sometimes with the way the measures move at the legislature, short notice of hearings, things like that. But I know that in other boards, they have different ways of approaching that issue, whether it's polling the members or taking a formal vote, or sometimes, it's a little bit difficult with the way things move to coincide with the monthly meetings. And also, even it's a good practice just to, if there's foreknowledge, to update us on things that we might want to weigh in on, or not, but at least be aware of what's coming down the pipe. And so even in a sense of protecting the executive officer and people from outside pressure, I thought there are better ways to handle the situation. And I have some ideas on that, but I'll let other people speak if they wish.
Thank you, Commissioner Lee. So I have on my own thought about, the items that you brought up and discussed with at the last hearing. I've also discussed it with Mr. Orendanker. I think it'd be helpful if I could ask Executive Director, Executive Officer to share kind of like what is the approach, history, even if not formalized policy, but how does it work? If you could share with us. So pretend we're at the beginning of a new legislative session and there may be bills of interest that, two members of the LUC.
Well, first of all, let me talk a little bit about, what happens in the past, and then I'll talk about what happens to staff as part of the administration, and then talk about what we've been doing, what we're doing now. There have been several different ways of handling testimony at the legislature throughout the years. My predecessor's way of handling it was to not to testify on anything under any circumstances, which was not serving the commission well. Subsequent to that, when I first started, I was following a procedure that was handed down to me from the governor's office as to how to testify on bills. The communication with the commission was to bring a list of bills that we were going to testify on to the commission ahead of time or at the beginning of session. And that was back at a time when we were meeting once every 2 weeks. It was regular meetings. And explain what staff's position was on the various measures and how we intended to testify. From there, it was just a free-for-all because, as those of you who work with the legislature know, you never know what's going to happen on a day-to-day basis, and amendments are made to bills, and you have a day to figure out how you're going to testify on it or whatever. So staff was given a lot of leeway with regard to how to testify on bills. And I should caveat that by saying that we have staff has a methodology by which we choose bills to testify on. And I'll explain that in a minute. Subsequently, we tried to put out what PIG together, which was a subcommittee of commissioners to work on legislation. But under advice from the Attorney General, since it was sort of an open-ended PIG and had no defined real purpose other than to just generally talk about legislation, we were told we couldn't do that. And then subsequent to that, the practice has been to, and we were recalcitrant this year in that we didn't have enough meetings. We should have probably scheduled a special meeting just to talk about legislation. But usually what happens is that we talk about the legislation at the beginning of the year or the beginning of the session with the commission. And then throughout the session, I am in constant contact with the chair to explain to him what's happening and, what we're doing. There are some exceptions to that. There are bills that we are told by the governor's office we must testify in support of, which we usually wouldn't even get involved in. And I think that the bill that Commissioner Lee mentioned was one that we never would have gotten involved in if we hadn't been instructed to. There are times when legislators have requested us to do things almost on a, tit for tat basis. And those I get uncomfortable with, and we very rarely do that. But usually, and this is what I was alluding to earlier, staff doesn't testify. We get, as part of the administration, and as part of the Department of Business and Economic Development, we have a legislative coordinator who goes through all the bills and then directs bills to the various agencies and boards and commissions that she thinks might be important to us. And it's very broad brush. I mean, and we get a lot of stuff that really doesn't impact us at all, or we have any desire to testify on. But then staff goes through those measures, and we only testify on measures that in some way impact Chapter 205. And usually it's to protect the commission in one way or another. We're not trying to create new law. We're not trying anything. We're just trying to point out to the legislators the impacts of some of their legislation and how it may negatively impact the operations of the commission or whatever. We stay out of bills that like, ethics practices and sunshine law bills, and even bills with regard to what can and cannot be done in the agricultural district, because as I've told the legislators, that's a policy call. That's not something that we get involved in. We leave that to the legislators to decide what's best. This transient vacation rental argument is one of those where we've just simply said it's up to you. But that's pretty much what we've been doing and how we've been doing it over the past several years. If the only time that we have gone further than that and gotten the commission more involved was when we were trying to, right after the Bridge on Alea case, when we were trying to fix that problem that Bridge on Alea created. And that was brought before the commission. They approved our moving forward with that. And because we instigated it. It wasn't something we were reacting to.
So take it one step further, if you will. When you make the decision to testify or when you've been asked and you agree to testify, what's the protocol for you making that testimony in writing and in person?
Well, when we testify on a measure, we're required by the governor's office to testify in a certain manner. It has to say certain things. There has to be certain opening paragraphs and ending paragraphs. And we follow that protocol and submit written testimony. We then attend the hearing where we submitted written testimony to answer any questions that the legislators may have.
So Commissioner Lee, you mentioned, I think, a phrase that was problematic for you in this particular case, which is, could you restate that, what that phrase was?
Yeah, thank you, Chair. I think the phrase was, the Land Use Commission strongly supports Bill X. And to me, that's a misrepresentation because we didn't opine on anything. And we might agree with it, we might not, but people will read that and assume that that is our stated and voted on position or official position. Now, I don't think it's a problem if the executive officer testifies, and even on LUC letterhead, that he supports this bill. In fact, it might even be more credible than all of us combined, possibly, and it carries weight. So I think that that's appropriate, but I'm not comfortable with someone speaking on my behalf on something when I didn't take any position on it. And now, if I'm outvoted on something, that's fine, but that would be the official position. But in the case where no vote was taken, I'm not really comfortable, and I think there should be a better way.
So, Mr. Arnecker, are you familiar with the phrase that was cited there? And is that part of the pro forma that you use, or directed to use?
Yes.
So please explain.
The governor's office has always given us direction on how and what we're supposed to say in our opening paragraphs. This administration has, for instance, told us that we're not to oppose any measure. We're just supposed to put comments, but we are supposed to put our support or our concern, the methodology in which we're testifying. In other words, if we have concerns, to start out by saying that. Now, that being said, I understand what Commissioner Lee is saying, and perhaps we can wordsmith some language that would be acceptable to the governor's office or to the director's office in this case.
Which director?
The director of the Department of Business and Economic Development, because all our testimony has to be approved by the director of DBED before it can be submitted. Yes, that's correct. So, I mean, I'm sure I could work with the director's office to come up with some different language. I mean, I can do it. I can probably find some way to amend the testimony to amend that opening paragraph so that it's palatable to the governor's office. I think that from a practical standpoint, the legislators view me as the land use commission. I mean, that's part of what happens. And I don't think it will change their perception much, but I can put that in there if it makes the commissioners more comfortable.
Commissioner Okuda.
Probably doesn't make any difference to me because I turned into a pumpkin in 15 minutes probably, but I think maybe Dan, the executive officer, one concern may be that because the land use commission is quasi judicial, if there's affirmative statement saying the commission takes this specific position and it's not qualified, you know, a devious attorney later might say, well, you can't render a decision differently than that in my DBA or my special permit application because you have stated for the record that this is the land use commission's position. So I think in explaining it to governor's office or, you know, the head of DBED, it's just that because the commission is quasi judicial, it kind of requires, I think, a little bit different way of presentation. But I do agree with Commissioner Lee that if a vote was taken, you know, and that assuming that vote was from a proceeding or hearing that was sunshine law compliant, properly agendized and things like that, then that's a different situation. But absent going through a formal process, I think it might be worthwhile just being a little bit more paranoid, you know, like me about what statements could be misconstrued. Yeah.
Thank you, Commissioner Okuda. I actually agree with you on that. I don't, I mean, part of what's happened here is habit. You know, this is just the way we've been doing it for 20, 30 years, and I'm not adverse to changing it at all. And I think that I can make a very strong argument, and that was one that I was already contemplating in my discussions with the director of Department of Business and Economic Development.
So what I'm hearing, and I agree with, is that we do need to revise that first paragraph if it's being used generically or commonly to better represent the actual situation. I mean, it's fair to say that we've, you know, if we've been briefed on the measure, that there's testimony to be offered, but we need to be careful that you don't convey that we've actually had a under sunshine law meeting and we've, well, as a commission endorsed or taken a position on the measure.
I don't have any problem with changing the first paragraph, for instance. I'm fighting to be able to do this, to say that this testimony is submitted by Daniel Haridanker, the executive officer of the Land Use Commission.
You're interpreted to be us by these guys anyway.
And so, and saying that, you know, staff's position, Land Use Commission staff's position is, and, you know, I mean, I'll ask the director if that's okay. And if he says fine, then I'm good with it.
Mr. Higashi.
Everybody's dancing around this pin. There's one.
Except for me, I'm stuck with it.
No, there's and I'm not a pumpkin until June, so I'm good. Anyway, there's this, yeah, you shouldn't be saying these things without our approval, right? And we can follow, you can pass a rule, you can pass a resolution, you can pass whatever we want to pass, or whatever we want to say. It says in order to represent the commission before the legislature, the executive officer must receive a vote from the commission. Then the governor comes out and tells you, hey, I want this and this and this in this testimony. Are we going to expect Dan to say, no, my commissioner says I can't do that? Or are we going to punish him, the executive officer, if he follows the governor's rules, knowing that we're just one cog in this whole place? It creates, in my mind, a difficult position for the executive officer. Is failure to follow that regulation that we required basis for dismissal, for suspension, for anything like that? Or is it something that everybody will say, okay, well, we understand because the governor told you to do it? And if that is the case, this discussion kind of is senseless, because democracy doesn't work unless people are sensible about it and self-restrained about it. So I'm just pointing that out. I'm a short timer. It doesn't bother me because I won't be around the next thing. But what we're failing to discuss is, what is the reality of the situation? How are we going to deal? How are you guys going to deal with a governor who says, or let's say not even a debate guy says, no, I want it this way. And what if he can't change it? He says, I want it this way. Are we going to say, no, but our rules require it? I don't know the answer to that. And yeah, I just bring that up because.
No, I appreciate that. I do. It's an important point of view. And I don't think it makes sense for us to create a bunch of rules and regulations internally of how we govern testimony to be made. But I do think we need to be cognizant of the issue that has been presented and come up with and as Dan as Mr. Orendenker has said, you know, he thinks he can find the words and make the case to satisfy the situation. So what I'd like to propose for general discussion and maybe concurrence is kind of a 4-part approach. And Commissioner Lee, you said you've been thinking about this, so if you want to modify my 4 parts or add a 5th or a 6th, you're welcome to that, right? So part 1, I think it's really important that at the beginning of a legislative session, that the staff, as part of its internal review, prepare a document that informs the commission of what bills might be relevant and what bills you might be testifying on and what impact they might have. And my understanding, Mr. Orendenker, is that you kind of do that internally anyway. Is that right?
That is correct. And I will be very honest with Commissioner Lee. This is the first year we haven't presented the list to the
Okay,
commission.
well, so be it. So part 1 is like, inform us as a group what's coming down the pike at the legislature. And within that review, do you tend to indicate whether there's an issue in a particular bill and whether you propose to testify or not?
Well, my suggestion, because there's so many bills that we have put in front of us, is that we bring in front of the commission the bills that we are proposing to testify on and what our testimony.
Yeah, that's what I'm asking for. Yeah. So step 1 is that you would bring before the commission at the beginning of a session, the relevant bills that you intend to testify on and on what perspective, right? Part 2 is an opportunity for commissioners and staff to exchange Q&A with each other. So whether you present that in a meeting and we do it on an agendized basis, or you don't, that's obvious. We can have a discussion about this bill or that. But if we don't have that opportunity, like we didn't this year, just due to our calendar, but you send that out to all of us, then if, I'm just gonna use your name, Commissioner Lee. If Commissioner Lee has a question or a concern, there's nothing to prevent Commissioner Lee from contacting Mr. Orndecker and having a discussion about it. So, but it'll be an informed discussion because you know it's on the list and you know he intends to testify, right? As a practical matter, it's going to be, I'm going to say impossible, not virtually impossible. It's going to be impossible for this group to meet under sunshine law to discuss on a bill by bill basis in a manner that's timely and supports the calendar of hearings and testimony that occurs at the legislature. So we got to give some leeway to those who choose to testify. So I would say that there's two opportunities. Number three is testimony by the executive officer. He's notified us of this. He's given each commissioner an opportunity to discuss concerns about it. Yet he's being directed or he has concluded on his own that he needs to testify. And important thing, I think, is what you just said. You can modify that testimony to make it clear that we haven't voted on it and you're not speaking for a voted consensus of the commission, but you're speaking as the executive officer and in that respect, probably the most informed person in Hawaii about these issues. And you got the freedom to do that, but subject to those modifications you talked about. The fourth part is, and I don't know the rules on this, so it's part suggestion and part question. If at the end of the day, any commissioner feels that unsatisfied and they want to testify on their own, they can do that. They can do that not as a commissioner. They could mention that they're a commissioner in their resume, but they got to just testify, if I understand correctly, as an individual, like we have public testimony. And you can do that. And you have the freedom to testify in opposition to whatever Mr. Orndecker said, correct? So that's my 4-part plan for how we go forward. Does that make sense? Or does anybody want to add a part to that? Mr. Lee?
Yeah, thank you, Chair. And I appreciate the comments from the executive officer. I know he's in a very delicate position and it's not easy. And I respect that. I think there's room for the executive officer to discuss with the leadership of the department that it's in their interest to find and craft a way to do this that doesn't hurt our operations and present us with liability or, other problems as Commissioner Okuda has brought up. Yeah, these things kind of change. We can all testify in our individual capacity, but we might not know unless we're informed that, some of the steps you brought are great, that a lot of times it's only 3 or 4 issues that are really that contentious, and other stuff is, not as important. But if we know that this is where, I don't want to prescribe any solution because some boards, they send out a copy of the testimony to all their board members when they do submit something and say, FYI, we just submitted this testimony. Some boards, even within DBED, will bring up, these are the bills, and they agendize it and they have discussion on every single one, and they sometimes even have it every month, I don't know that that's the practical answer for us. But I just want to have some discussion of what the policy is and that we're informed if something happens, that a position is taken. Sometimes positions can be very controversial. Sometimes, like you said, we might be able to finesse a better answer, with all the minds here and provide input. That would relieve some of the pressure from the executive officer to take the sole brunt of any criticism. So I think it works both ways, and I do appreciate having this discussion, and I hope that the powers that be will see the wisdom of taking a different approach. Thank you, Chair.
Thank you. Anybody else? Mr. Carsmith?
Yeah, just briefly. So when the governor asks you to testify on something, is that one of those items that you've learned about at the beginning of the session, or is it something that comes along midway, random? And I'm just curious, what if the commission wasn't in favor of that? How would you feel about that?
Well, as far as what if the commission wasn't in favor, I don't know how to answer that. We do live and swim in the governor's pool, so we have to be cognizant of that we are a part of the administration, although the commission has granted a lot of independence, but we are a part of the administration. So when if there's something that I get instructed to testify on in a certain manner, that's what I do. As far as when and how those things happen, sometimes we get a lot of heads up. We get in the summertime when everybody's putting their packages together. The governor says, okay, I want an initiative from this organization or that organization, and I want everybody to jump on board. And I get this through the director's office. That's how I get the communications, is the director will call me usually. Sometimes I get calls from the governor's office, but a lot of times it's just the director will tell me, this is what the administration's position is. We want you to support it. The difficulty comes when a bill is submitted at the end of the allowed submission time, because there is a deadline on when bills have to be submitted. And it's not something that anybody contemplated or was discussed with us or anything like that. And then I start getting calls usually from legislators and sometimes even from a congressional delegation on, they want me to support it, or they want me to make comments that will allow for amendments and things like that. And then I don't have a lot of time. I usually communicate with the chair what's happening, but those are very, as Brian pointed out, that puts me in a very awkward position because, as I say, on the one hand, we're swimming in the administration's pool, and on the other hand, we are a 9-member commission, so there are different views on things. It's very fluid, and the only things, this one particular measure was an oddball, and we didn't get the request to testify in support of it until it was, until actually, it was brought to our attention, and then I got a phone call afterwards, and it's just one of those political things. But usually the only things we're testifying on are bills that impact Chapter 205. And for the most part, unless all of a sudden this commission decides it wants to dissolve itself, what we're basically doing is trying to support the commission as an entity. There are a lot of bills that I testify on. Over the years, not in any one particular session, but there are a lot of bills that I've testified on where we haven't weighed in on the measure at the beginning, but an amendment is made, and all of a sudden we look at it and we say, there's no way we could implement this. We got to get the language to change, And so a lot of our testimony is basically assisting the legislators in crafting something that makes functional sense.
So Dan, tell the commission, I think each of us have heard pieces of it, but at the end of last legislative session, there was that bill that underwent a major rewrite right before the last day of the ledge. And you got involved. How'd you get involved, and what was the circumstance?
Okay, so there was a measure last year that was moved its way through the legislature that would have raised, in a nutshell, it would have raised the minimum from 15 acres to, through most of the legislative session, some negotiated larger number. And as it moved through the legislature, on the House side, it was still amorphous. But when it crossed over to the Senate, one particular senator negotiated, I think it was 30 acres for the new cap. And then it went into, it passed both houses in different forms, and then it went into conference. And 2 days before the session ended, we got a copy of what had been the conference committee was coming out with. And initially, it was an amendment. Thought we could make an amendment that could make it work. So we contacted the conference committee chairs and said, look, you know, if you change this language or that language, it might be palatable. Well, they then went back in and gutted it even more and basically reinserted a bill that had died in place of the bill that had passed. And that popped out the day before session ended. And it was, I started getting phone calls from all sorts of people involved in land use who were upset about it and so forth and so on, and asking me to help them in getting the measure held until the following session when it could be fixed. And I had 24 hours to act, and that was my position, is that, hey, look, you know, it's not that this is a bad idea. It's just the way that it's currently written, it doesn't work, and you should hold it over until next year when we can fix it. But I didn't have any time to talk to anybody about that. That was, you know, I woke up in the morning and there it was, and I immediately had to jump into it. So, you know, that's the kind of thing that I have to deal with sometimes.
So what happened to the bill?
Well, we got the bill held in the end, and it died on the floor actually because it conference committee had already voted it out, and it died on the floor in both houses. Or actually, I don't think it died on the floor. I think that it was decided that it was not going to be put to vote. I think that's more accurate. It was decided on both houses that it was not going to be put to vote. And, you know, the next session came around and the authors of the bill decided that they just didn't want to pursue it. And so it didn't move.
And so first I as chair, you know, and Dan, you do a great job proactively giving me heads up on things. This happened so fast. I heard about it after the fact. It had already died by the time he came up for air to tell me about it. Yeah. So, I mean, that's the reality of the world you live in.
Yeah. It's not fun. My wife starts feeding me stress relief vitamins at the beginning of every session. And my staff tiptoes around me for a few months. You never know what's going to happen on a day-to-day basis. I mean, I literally get calls from legislators saying, hey, look, I need your input on this. I want you to come to the hearing and explain to me why this is not a good idea so we can amend it in a proper manner. You know, I mean, and it happens that quickly. Usually I have enough time to call the chair and tell them what's happening sometimes, but sometimes it's the morning of the hearing, you know, and they ask me to come because they want me to straighten something out.
But it's an FYI. It's not a, what do you think? How should I testify? It's just an FYI to me. Yeah.
Because as I said, 90% of my testimony is, look, if you're going to do this, the way you've got it written doesn't work. You have to do it a different way, you know.
Mr. Lee.
Yeah, I appreciate this discussion, and I like the governor. I don't agree with him on everything, but he appointed me. And I think if the governor or the director at DBED were to understand some of the issues that we face, that Commissioner Ohigashi and Commissioner Okuda brought up, that, you know, it has ramifications beyond just simple written words, you know, I think that they would then be more amenable to some of the ideas on how we could temper the testimony. And yeah, there's no time to be directing the executive officer every little step. I mean, you know, on the whole, he knows what he's doing, you know, and he has more knowledge than, like I said, probably all of us combined on these issues. And so I think his testimony carries weight without presenting liability to us. And I'm pretty sure that you can come up with a way to,
Find words.
to present a way to testify that wouldn't cause harm to what we want to do. And that you would be able to explain that.
I would propose to Commissioner that by next September or October, that we come up with language, I get it approved and get this commission to approve it. And then when session rolls around, as soon as we can possibly we come with the bills and talk about them.
Yeah, and written testimony is different than when you have private discussions with legislators as well. So as you know, there's different avenues of presenting what your position would be on things.
Yeah, I like that. Let me just add though, in contrast, that if you see a bill that is very much something you'd like to testify in support of, and you have time to bring it before this commission and request the support of this commission under sunshine, I don't,
Most certainly.
yeah, and then you could write that letter that says, we discussed it, we voted on it, we like it as a commission. But at least we've gone through the process, right? So that option is there if time presents itself and can be done. Commissioner Umani.
I thank you. I just wanted to state, I've been in our executive officer shoes. My last 18 years at KUC was strictly with legislative affairs and representing our company and talking to our board of directors on positions that we're going to take on bills. So I really appreciate what you have to go through. I can tell you right now, I fully support our executive officer saying the land use commission. I don't have any problem. Whatever we do, I'm okay with it. But just for the record, I mean, it's hard enough already with all the other issues that commissioners will agree or disagree on. But I just wanted to go on record that whatever our executive officer does at the legislature, I believe is in the best interest for the land use commission. And it's not opinionated on any petition requests or anything. It's something that will protect the land use commission. So I fully support our executive officer representing the land use commission. I don't think we need to make special languages. We should have a backup if the DBED director or governor doesn't accept that. There's a possibility. But what I have learned, and it is helpful having to deal with our legislators, is some blowbacks of positions of the company or the commission. And one thing that helps is what we're already talking about is, here are the bills that are coming up. Here's the position that land use commission is going to take. This is why it helps the commission. So that's what we already talked about one. And then we can have discussion and commissioners can agree or disagree or fine. But I think more importantly than that is the potential of our own legislators representing our islands coming to us and saying, hey, Mike, what is the land use commission doing supporting this? You on the land use commission, you support this. And what is helpful and our executive officer being around the legislature for so long, I think you can kind of tell that this might be a sensitive issue with this legislator or this legislature. So here, Mike, this is a heads up that this is what we're doing. So if you get any kind of blowback from other legislators, this is what you can tell them. Yeah. In other words, inform us so that when that happens, we can say, this is why we're doing that. That was, I think, in my years of experience, the best thing that I can do is not, because you guys are the experts on the land use, on what is best for the commission. But we just need to know why that is, so that when we're tapped on the shoulder or yanked on the ear and says, you're on the land use commission, what do you guys do? We know what to say. I think that was the most helpful for me when I'm dealing with representing a company as on behalf of the whole company, but yet knowing that this legislator knows this board of director and that they might approach, but I need to make sure our board of directors know that this is a potential so that we're informed and ready to answer and defend, honestly, our position. So just wanted to say thank you.
That's very helpful.
One small comment.
You're not a pumpkin yet? Okay.
No, yeah, I agree with, Mike, but what struck me was that Dan O utilizes all possible levers to try and see if he can understand or try and see if he can fix an issue. I know he has called, I would call me, but I referred him to my wife concerning certain issues with certain legislators. And I think his ability to find out true positions and try out and contact all these legislators, whatever the assistance he gets, is one of the attributes of it, that I think is important in this case. I think this is an excellent discussion as to what the reality in life as the EO does. And I think that it's important that we don't leave out the fact that we are political animals. We are. And and it's not a bad word, political. It means we're people animals. We have all different interests or all different competing interests, and we try to leverage whatever we can to try and see if our position comes correctly. And for our executive officer, I think his motive is what is best for the Land Use Commission, like Mike Miamani says. And I think that this kind of discussion shows that he has that ability to care for what the organization is and to keep it running. For him to defy the governor, for him to defy his debate would reflect badly on the commission's work, and not in overt ways, but in subtle ways. And that's, I think, the balance, and I like to congratulate him for trying to keep that balance in this kind of situation.
Thank you, Commissioner. I mean, I think this has been a really healthy discussion, and I've learned a lot from it. And hopefully, Mr. Arndenker, you've gotten a little bit of guidance that will help your job be a little bit easier.
Yes, Chair, thank you.
And I think it's about communication. Just keep us informed, and especially at the beginning of a session.
Most certainly will do so.
Yeah, great. Any additional comments on this by anybody? Okay, we're good. We'll move on. I'm gonna do this first.
Oh, okay.
Okay, our May 8th meeting will be held at the University of Hawaii Maui College. Their cafeteria is expected to be closed, so this commission intends to work through lunch. I would request staff to arrange for a lunch to be provided to the full commission and to facilitate that meeting. Can I ask for that? Thank you. We have one more agenda item, and this one comes with a heavy heart. It's aloha to Gary. So this is Gary's last official. This is your last meeting, huh? So Gary, when does your term end? Officially?
Yeah, I think April 28th.
April 28th. We're not scheduled to have another meeting in April, so this might be the last opportunity that we're here as a group. Looks like Dan wants to do something. So Dan, what you gonna do? What you gonna do? And then
As the oldest member of the commission. As the oldest member of the commission, I'm going to give you my personal gift to you. That you're going to win. You're welcome.
Commissioners that I knew, Gary is famous for, we have a spread instead of just individual sandwiches. Putting out a Ziploc bag. Putting. There you go.
How about the cheapest one?
Thank you very much, Commissioner Ohigashi. I promise that I will stay in touch with you in the future because you are one of my truly people that I really, really look forward to seeing you. So I really appreciate this from the bottom of my heart. I can't tell you how much I do.
Mariana is telling me I have to use the microphone, so I'm gonna move over here. And then I just want to say that it's been a pleasure having Gary on the commission. He came on reluctantly, but he has been a welcome addition. I respect his intellect and his dedication and his commitment to the community and what is best for the community. We will be sorely missed, and I hope we will stay in touch and we'll stay friends. He has been a wonderful addition to the commission, and it's a pleasure getting to know you. And with that, we have a plaque for your participation, which you're free to.
Well, that's my new gavel. That's what you did with it.
Right there, which you're free to plant with your naupaka. For Gary, yes. We're retiring your number.
I have nothing to say.
Well, we're not gonna let you get out of here without saying something, but before we give you the microphone, I mean, anybody could speak, but I just want to put a couple of words out there to myself, Gary. I mean, I knew LUC stood for Land Use Commission, but that's about the extent of my knowledge of how this place operated and what its business was. And, you know, and this point in my life, I just want to do things that are meaningful to Hawaii. And I can say quite simply and honestly that you showed me the way personally. You took me under your tutorage and educated me incredibly. And I just thank you for that. And I thank you for your patience with me and your support every step of the way. And we've never had a hearing in which you chose to speak that I didn't learn something. So, and more than anything, you taught me, boy, am I glad I didn't ever become a lawyer. Because I don't want to be one of those, but I do absolutely respect and appreciate what you've done for this commission and for this community and for our state. Thank you very much, Gary. Anybody else want to say anything? Okay, Commissioner Ohigashi.
I want to thank Gary. He did the tough work sometimes. And a lot of it is because we're lawyers. And what we know is that if there is nowadays you can appeal, anyone can appeal anything. Technically, if today's hearing, it can be appealed by somebody sitting outside. And they'll have standing. During the time that I've been on the commission, Gary has made sure that there is a record that we can follow. He has made sure that there are points that we can rely upon. And one of the best things I've known about him, and I'll say this truthfully, the best things I know of him, in the Hawaiian Memorial case, when he voted against the issuance of the DBA, he assisted in writing the findings of fact to make sure it stands up.
Yeah.
And his fee was very little. No, he did a bit for that. So I commend him for his service on this land use commission. And for all of us who've had to endure the constant and long questioning that he had, and who have made the snide remarks that I have made about him. I want him to know that I appreciate it. And I appreciate him. I appreciate him from the very beginning. And he's voted with me a couple times when I was alone. And I want to thank you. And I'm going to miss you, Gary, but not that much.
Okay, Gary.
Yeah, I won't take more than half an hour. But
Take all the time you want.
no, I'd like to thank everyone. I'd especially like to thank the staff. I told Dan Orndenker before that I believe the Land Use Commission staff is the best planning firm in town. When I first came on the commission, which I've told everybody was a fluke, that I wasn't supposed to be appointed. I was just picked because at that time, the first preference person decided at the last minute not to serve. My first comment to Dan Orndenker was something on the lines like, I don't know why I'm appointed to this commission. It's just full of crooks. Yeah. And my citation to that is Gavin Dawes' book, Land and Power in Hawaii. Yeah. Well, I found that my assumption, like many things, was wrong about that. And in fact, a lot of assumptions that I've had going into these hearings were wrong after I listened to the evidence. So I really shouldn't have been here for a lot of reasons. I can tell Nancy Carr-Smith later on some stories of my grandparents, in the Waikea house lots, before the ILWU had organized the docks, and how the Luna would come over to the house, and you don't bribe the Luna, you don't work the next day. So, I shouldn't be here. But I guess, when you say this is America, that's the good thing about being in America. So I thank everybody. It's been a great experience. I know the commission is in good hands going forward with a lot of people who have experience here. And but I promise I will try to avoid seeing all of you, so you don't have to be stuck listening to me for the last half an hour. Like my wife always says, why do you keep repeating the same story twice? But my answer to her is she could have been married to these other guys and she would still be working. So anyway, with that, plenty thanks to everyone, and appreciate all the good things that have happened over the last 8 years.
Gary, would you mind if we collected and asked maybe for somebody to take a photograph of us?
That's fine.
Yeah, so when I adjourn the meeting, but thanks, Ariana. Anybody else want to say anything? Okay, this meeting is adjourned.